My lord, in this matter, I have been requested to appear, but can it be on 4th of December?
Okay, you file, ask you somebody to file the counter also.
Counter has been filed.
File? No counter.
Counter has been filed.
File, counter file.
Yes, Lordship, this reasonable time has been given. I have not received. That I am trying for this step. That I am, Your Honor, that I am trying for the stay of this.
Time for
They're trying for this stay of this.
stay of what?
It's a challenge to the act.
Your Honor, that I am challenging the act, Afafa Act, for the strike down.
There cannot be any stay as such to a legislation.
For operation, Lordship, this operation of this.
That cannot be. There is a direct bar. There should be an exceptional case.
Lordship, there is completely this against the basic structure of the Constitution.
No, we understand it. A presumption is always in favor of a legislation. That is the law. So we'll have to admit this because it's a requires a hearing. A response is filed.
My lord. When was it?
But office note 811 says that counter affidavit not yet filed. And there is no counter in the file also.
Please check up.
No, not filed.
I'll tell him to cross check, and if not filed, we'll file it immediately.
Okay. It is the present public interest litigation is filed assailing the constitutional validity of the Arunachal Pradesh unlawful within bracket preventive act 2014 full stop. Activities Prevention Act, Unlawful Activities Prevention Act 2014. The learned Advocate General has entered appearance in this matter. Full stop. It is submitted by the learned government advocate that affidavit has already been filed, though office note dated 8/11/2023 reflects that no affidavit in opposition has been filed. Okay.
He will verify. If not filed,
Registry will registry as well as the learned government advocate shall verify, and if no affidavit has been filed, same be filed within a period of
1 week. This week itself. It is ready otherwise.
Within a period of 10 days from today. Full stop. As the parties are duly represented, admit this appeal and fix it for hearing on
4th of December.
4th of December 2023.
Right.
Sorry, Balad, I was out of station.
What is the present status of the work? Work order issued?
My lord, work order as such, it has not been issued, my lord. The tender has been almost finalized, my lord. Now,
My lord, let me explain. My lord, process is almost completed. Only my work order is to be issued, my lord.
Only work order to be issued.
Yes, my lord.
Now, what is your stand?
My lord, my stand is
The
that
learned single judge has come to a conclusion. And who is for the private respondent?
my lord, this for it.
Learned single judge has come to a conclusion that there is substantive compliance of the clause.
Para 50.
Filing affidavit.
Para 50.
And thereafter, however, relying on the judgment.
Jagdish
Jagdish
Mandal.
Mandal.
Jagdish Mandal denied the thing. But if you see the Jagdish Mandal, there are 2-3 exceptions are there where public interest is involved, and some 1 or 2, 3. Now, if there is a substantive compliance and stand of the government, and even in the Stamp Act, the learned single judge have come to a conclusion that so far relating to affidavit by a judicial magistrate, it should relate to the judicial proceeding. Is it a judicial proceeding? So if that is the findings, it hits at the root of the matter,
My
number
lord, first,
one. Number two is, public's interest will be served if more participants are allowed to participate.
yes, my lord,
Suppose
16,
his price is less, government is in a benefit.
my lord, 16 took participate, my lord, 16 bidders, my lord.
Huh?
Out of 16 bidders, my lord, 3 qualified.
Hmm.
And out of the 16,
And-
one of the appellant, my lord.
Then how
Now, my lord-
many were rejected on this ground?
My lord, now we have to see whether this rejected 16 bidder, they have complied with the terms and condition of the NIT law.
Hmm.
The terms and condition of the NIT says, my lord, all the affidavit which are specifically mentioned is to be shown before a first class magistrate.
So what do you mean by first class magistrate?
My lord. My lord,
Where
when
is
you,
the definition of first class magistrate?
my lord, then we have
You
to,
in a different case, you state that it is our mistake. Now, what is
No.
the interpretation of magistrate first class?
my lord,
Is it a so fatal defect?
Your
my lord,
Honor.
that is, my lord, that's how my lord, things started, my lord. My lord, first NIT was my lord cancelled. My lord, when seeing that the Arunachal Act 2015, that Enterprises Act, my lord, which only speaks about the affidavit, it does not say first class, second class, third class, my lord. It only talks about the affidavit. Then we thought, my lord, since this is not in consonance with the that act, Enterprise Act 2015, my lord, then we cancelled that. Then we went for fresh NIT.
You took a stand that it should
Ma-
have been.
Yeah. Then we went for fresh NIT. That fresh NIT was challenged by one,
Another, one of the.
yes, another enterprise. Okay, enterprise.
Don't.
Dawn Enterprises, my lord, saying that, my lord, since tender process has been already started, my lord, it has to be come into a logical conclusion. Then our stand was that because of that, my lord, we have cancelled. But that was not accepted by the land single judge, my lord.
And that.
But that remained, that attained finally.
That attend finality. Beside that, my lord, now, my lord, the present appellant to participate entire proceeding, never challenge, never hesitate before the terms and condition of that NIT, my lord.
No,
After
those are
taking
correct.
participant
No,
in-
no dispute on all those facts.
Then,
A vital issue here is the affidavit. Is it so fatal? Suppose, assuming for a moment that it is treated that it should be either, we are not interfering with any other participant, only what this court minds, subject to, this is not the final idea, because we will give you a patient hearing. Only thing is that, is it so fatal? And will it serve the public interest? If you go by Jagdish Mandal,
yes,
the
My
third clause is public interest. The public interest will be if there is more participation. Suppose how many persons you have cancelled on this count?
13.
out of 16,
13.
13.
Suppose you allow all the 16 participants and you get a lesser price. It's a saving of government exchequer. Kindly come to that paragraph of the judgment, Jagdish Mandal.
Para 22, my lord.
Para?
Para 21 and 22.
No, the learned single judge.
That is, my lord, page 354.
My lord, before that, my lord, you lordship
No,
to
no,
see,
just-
my lord,
we'll,
My
I hear you, just, these are the bird's
But-
eye view of fundamental.
whether the
questions.
terms and condition of NIT bearing should be important or not. my
No, we are aware of the fact that the author is the best interpreter so far relating to tender, how to interpret it.
lord.
There is no quarrel
No
on that,
quarrel on that.
My lord.
no quarrel on that.
Then secondly,
But will that take away the right of judicial review
yes, my
in
lord.
view of Jagdish? Mandal?
secondly-
Kindly come,
sec-
page 14 of the judgment. One,
Correctly.
whether the process adopted or decision made by the authorities malafide or intended to favor someone. Okay, this is not.
This aspect,
Okay, just come or whether the process adopted or decision made is so arbitrary and irrational that the court consider decision is such that no responsible authority acting reasonably and in accordance with the relevant law could have reached it. This is the finding of learned single judge that it is a substantive compliance. It is the findings of the learned single judge that as per the Stamp Act, only
court action.
judicial magistrate can accept an affidavit on oath where in the judicial proceedings only. If that is the finding, where is the question? Will not go to that because many others has filed under judicial because then we'll have to interfere it. Now come to the two, whether public interest is affected.
Yes.
Now come to, if the answer are in negative, there should not be international cases involving blacklisting or imposition of penalties or a teacher or disturbing or distribution of state largesse. State largesse stand on a different footing as they may require a higher degree of fairness in action. So it involves a state largesse. Suppose any of these 13 person offers a lesser price. Is it the interest of the public interest, the public exchequer?
Madam, your lordship will see, madam, how many bidders they have qualified. Before that, madam, whether any prejudice caused to the petitioner or not. Number one, is there any violation of
My lord,
Article 14, madam?
My lord,
My lord, wait, let me finish,
my lord,
let
may
me
I
finish.
When court is in your favor,
Let me finish. My lord,
you take your seat. Okay.
now, my lord, petitioner has to demonstrate, my lord.
Hmm.
Inserting first class magistrate, because my lord, the Arunachal Enterprise Act is does not talks about any magistrate. It only says affidavit.
Hmm.
So to clarify that, the tender committee, they have inserted only the affidavit. These are the documents.
First class
to be-
magistrate,
First class magistrate.
but not judicial.
It does not talk about the first class magistrate, judicial or executive. Only
So
first class.
therefore either will fulfill the criteria.
My lord, now my lord, swearing before a second class magistrate, they have sworn before the executive magistrate, which is second class magistrate, my lord. There is a differentiation between the first class and second class. When you see the CRPC, difference are there. Now, my lord, while doing that, is there any, my lord, any fundamental right, legal right has been violated or not? Can he be an aggrieved person after participating in the process? After rejection, my lord,
No,
yes, approach the court.
after rejection is his cause of action.
No, my lord.
Because
Malay, he's
according to him.
No, my
first
lord,
class
he is very aware that the mandate says that first class magistrate, whereas
Not
he,
judicial mistake.
no, my lord, but he, my lord, affidavit is shown before the executive magistrate, second class, my lord. It's executive magistrate, not first class magistrate, my lord. So that is the one of the
How
ground.
will you
But
answer, how will you answer your validity of action of a judicial swearing in before a judicial magistrate? Are our judicial magistrates are having no other job but to get us affidavit swearing? We have not authorized them to have an affidavit declared under the oath act. We have authorized them for the judicial process only.
then, my lord, we
Now
have to-
then your whole tender clause will go on that basis.
then, my lord, we have to look back to the CRPC, my lord. CRPC.
We'll look
What
back
is
to
first class
everything.
magistrate and what is their authority, my lord?
Kindly come to the findings of the learned single judge. Kindly come to page 12 of the judgment.
Next,
Paragraph 15.
15, that's my answer. Really.
Yes, my lord.
Without prejudice to the powers conferred by subsection 1 or by or under any other for the line
Page 12.
law for time being in force, any court, judge, magistrate, or person may administer oaths and affirmation for the purpose of affidavit if empowered in this behalf.
Yes,
A, by High Court in respect of affidavits for the purpose of judicial proceeding.
that's why we have a oath commissioner, my lord.
The state government in respect of other affidavits.
Affidavits, yes. My lord, for specifically for this A, my lord.
Ah,
That's why, my lord, your lordship, my lord, there is a oath commissioner appointed by the High Court, my lord,
yes.
for that purpose, my lord.
Ah,
And so for B is concerned, my lord, is state going to be respect of other affidavits?
I were not understanding why the state is opposing a larger participation.
My lord, we are not opposing larger participation, my lord.
And,
Now-
and it is a substantive compliance is there.
We do outmost
Because
satisfy, my lord, I differ with this, my lord.
what is your intention of the affidavit that he makes an oath? Oath
Yes, my lord.
that there is no other more than 2 oaths going on. First, this is for the purpose of distributive justice, so that one person will not get more than 2 oaths. This is small work, it's a distributive justice. Of what is the object of that? And second is that what was the other declaration that he will complete the work within the period. This is the affidavit.
My lord, in the NIT, my lord, NIT, documents point 2.0 specifically mentioned, my lord, these are the affidavit. Has to be in the
Let's
court
see that.
paper, has
Yes.
to be in court paper, shown before a first class magistrate. My lord, first class magistrate. Now that is the terms and condition. Now terms and condition, my lord, is a part of my lord, is a contract. Is a part of
Yes,
contract.
sir. Tara,
So
in-
can he deviate from the terms and condition, my lord? Can you allow them? Suppose if we allow them, what about the three others, my lord, who have completed, my lord, complied with all the terms and conditions, my lord? There are three other persons, my lord. We cannot ignore that also, my lord. And we have exercised because of the honorable court's directives, my lord.
no, those persons who has come, who we are not interfering with anybody. Suppose even if we interfere, we are not interfering with the tender process. Only thing is that we'll ask to open their price bid.
That's
That-
our contention only.
That's no. Now tell us. There are some judgments, even dealing with Jagadish Mandal, where it is says the defects substantive compliance, defects curable, defects not curable.
But that exactly that judgment I have not brought, but I have brought the recent judgment that Madras Aluminium Corporation Limited case. Even in the realm of candor, the mandate of Article 14 must be complied by the
No, that is there, but here basic contention is law is well settled.
The most
Whether you say Tata Cellular or Jagadish Mandal or subsequently some other judgments, where it has been said
Well,
that
that-
it is the author who will best interpret what they require.
Even, my lord, that GN,
After-
then Tata Motors, Onsara, these are the latest judgment of Supreme Court, where is relied by law.
It
Jagadish Mandal.
says that it is the person or author who will
Well,
interpret what is
I have that
what is
judgment.
what they mean. So if they mean first class magistrate, that is their argument.
I'll
And
demonstrate.
say court says that Supreme Court says that please do not interfere. You are not an appellate authority to interpret what is in the mind and the invited who has invited the tender. So, but we'll have to make a balance. Judgments are here also, there also. But there are judgments which says which are the defects curable, which are the not defects curable, not curable defects. And what is the substantive compliance? When in certain cases, in curable defects, if there is substantive compliance, in fact, there are some judgments where that bank draft, yes, it was bank draft was to be issued, then it was given a check, so tender was rejected. Those judgments.
There are Katina, Milord. I
So
today,
give us.
Milord, I came back, flew back from Delhi
Okay, so
yesterday.
we'll take it up
Yeah.
on Monday.
No, Milord. Now I'm ready. Or if Milord says, then kindly.
I'll continue.
Milord, I will fly back.
Now
by-
we are clear about Monday.
Yeah, Milord, I will fly back by 3 o'clock. So
On
my-
Monday.
No, now I'm flying back by 3
Ah.
o'clock. My wife is in hospital,
Okay.
so I can able to come on Tuesday morning. Then Wednesday I can
How
complete.
will
the-
you have it? Because see, whatever he has argued, and one thing you'll have to remember, this is an intra-court appeal.
Correct. Milord.
This is an intra-court appeal, and there are judgments on intra-court appeal also, where it says that generally, until and unless it is perverse, it should not be interfered.
That NG product.
So this
No, no.
case is
NG product is
a case where both side we can go with both side.
Either issue at that side.
I absolutely marginal case for you. So you'll be better prepared and when on Wednesday.
Milord, I am very loud and clear about this case.
Hmm.
They cannot dilute.
No,
the
we'll,
statute.
let us not waste time.
No,
If you take it
Or
up on
else, my
Wednesday,
lord,
Wednesday. Milord.
Wednesday,
Wednesday.
we'll take it up on Wednesday.
that's how, my
We'll
lord,
dictate
things
in
have
the
been,
court itself.
my lord, no more adjournment, my lord. You-
No, no
when
more
I-
adjournment.
my lord,
Because
you finish, my lord.
this is a
Milord,
case
I am
where
the only counsel who
no,
opts for the
because
adjournment.
this is a public project, a road
Yes,
construction of
absolutely.
road. That is the anxiety behind our.
I have well informed them, all the parties, that this is my situation today.
No,
No, no,
know that. We have-
I informed you on the court also.
I don't seek
we
adjournment
inform the court also.
unless or otherwise if there is
See,
situation
so
warranted.
this court can go till this side also, that side also.
Balance. Which one is heavier?
We'll have to balance the interest.
Yes, whereas partial
We are-
interest or
we are-
public
our
interest,
only
you not
interest
supposed to
is the
balance.
public interest.
Let there
Nothing
be,
more than that.
let there be no predeterminants for both the parties.
There is no.
Equity, we come here in the temple of justice.
Yes.
We seek equity only.
And
As
you
a
have the
council,
judgment where
they are
it
also
says that,
representing government. I am
is
for
the-
my council.
You have the judgment. No?
My lord.
You are the the
Yes, yes, my lord, yes.
tender preparing
Yes.
authorities, the
that-
base us to
Yes, my lord.
Well, I
interpret their tender.
Well, I tell the judgment now, anti-agency, please look into that anti-agency judgment. That particular paragraph, I assisted L. Lakshmi Narayan in that case.
My lord, that
Yeah,
has been
it clearly
repeatedly
said
said, my lord, even Tata
that-
Motors also, my lord, listen.
Tendering authority is the best author.
Yes.
So if that is so prescribed,
No
but
dispute on that.
for the moment, my lord, that paragraph,
No, we will not waste our time on Wednesday. On Wednesday, come prepared.
if their argument, whatever they advance, I can tear apart.
Yes.
I
We'll
have
see that, my
prophesy
lord.
We'll
cases.
see
in
that on
See
Wednesday.
that when times comes.
On Wednesday.
Great, my lord.
Not today.
Interim to be continued.
As agreed to by the learned council for the parties, please this matter on Wednesday.
Wednesday, great.
We'll
Malata-
do after finishing the other matters, we'll take up this one.
Since your lordship is extending the, my lord, the interim order, your lordship may kindly bear in mind what says a NG project, my lord.
No, no,
The
that-
price
that-
escalation.
That's why that's why we have fixed it today.
Yes, my lord. Price
That's why
escalation.
we fixed it today.
Yes, in case, my lord, yes.
In
he will
fact,
be ready
not,
for that.
okay, on Wednesday.
When, my lord, I am coming back on Tuesday morning only.
Yes, yes.
And then I have Wednesday, I am saying, I have a genuine difficulty, my lord. Otherwise,
No,
I
no,
am a
I
council,
know.
you never seek adjournment. my lord.
Yes.
Grateful. Interim, will continue. Interim to
Interim
be-
order to continue till the next day.
Grateful.
Your lordship.
No, no, same
Yes.
situation in item 5 also.
All right.
All the item. Same order,
Item number 5, may I lordship, please?
same order.
Same. Next, day, granted, after 4 weeks.
Same order, no? Here is paper ready, as regards ready paper book. Third. After 2 weeks for hearing. You have all received the paper books? Same here also,
My lord, IA is there, my lord, in this case, my lord.
IA for
Suspension, my lord.
suspension.
Here,
Where is the IA? What is the offense?
opens, my lord, 302, 326, 447, my lord, conviction, my lord. Now, but then, my lord, here my humble submission, my lord. It is a case, my lord, in any circumstances, my lord, 302, my lord. Would not be sustained, my lord. At the maximum, the punishment under would be 326, my lord. This is the, as per the record, my lord. Now, this person, my lord, had already served more than 6 years, my lord. Now, punishment given under 326 in this case is 6 years, my lord. So, my humble submission, my lord, in this case, my lord, he was arrested, my lord, on 2006, my lord.
Just a minute. What is the evidence of injured victim?
Injured victim, my lord, for 326, yes, there is a witness, my lord.
No, no.
Evidence,
No, no. There is an allegation that you have started cutting the on goers. On the
yeah, my
road,
lord, randomly, my
okay?
lord, randomly, my lord,
Randomly.
my lord.
Out of 5 people injured,
Ma-
1 died, girl died on the spot,
My lord.
and others got injury.
Yes, my lord.
What is the evidence of them that you are doing this?
Evidence, that's why I'm saying, for 5,
They are the eyewitnesses.
no, my lord. For 5, my lord, there is evidence, my lord. Eyewitness is there, my lord. But for 1, my lord, who died, my lord, there is no single direct evidence, my lord. Only due as, my lord, this happened in sequence, my lord.
But it is a situation established that you did it at the place of occurrence.
No, my lord. A place of occurrence also, my
What
lord.
is your explanation?
Place of occurrence also is for all victim, it is different, my lord, not a single place of occurrence, my lord, in this case, my lord.
What is the period?
Period, my lord, my lord,
Life.
my lord.
So affidavit. You'll have to file an objection. More than 10 years. You have a right or you are not filing.
Lordship, here Lordship will go for argument, Lordship, because Lordship, as per my this
No, since he has filed an application, you'll have to take it up.
Lordship,
You may say that let the matter be taken up for hearing.
Lordship,
That is one aspect of the matter.
Lordship.
He has filed an application. So either you say that we'll file an objection or we'll record it, we'll not file an objection. Then we'll have to take the IA.
Lordship,
Either we dismiss or not dismiss, that is a different issue.
Lordship.
But when offense is more than 10 years, rule says that we should give a chance to the public prosecutor or the informant to file an objection. Now it's life imprisonment. Will you file an objection to this?
Lordship, I'm
You
praying
should.
for Lordship, so that Lordship, all the voters will be heard together for the appeal also, Lordship, because this is very serious matter, Lordship.
No. Serious matter is the allegation.
Lordship,
Suppose he establishes that no case is made out, why should we not? It's not that even it is allegation is murder, therefore it's murder. We are not saying anything on his, but this is the principle of law. If we are prima facie satisfied that no, it's a case of acquittal, then definitely we'll give him a bail. For that, the prudence and rule says that public prosecutor should be given a chance to file an objection when it is conviction is more than 10 years.
My lord, I believe, my lord, that right has been waived, my lord. This is pending since more than 2 years, my lord. My case, my lord. It is
But it's not a case for.
already 2 years, my lord.
I have been close to ultimately. His praise for the way.
Lord,
Or if you agree, we'll fix it for hearing.
Lordship.
My lord,
It will be much better.
no, my lord,
Or if you praise for the IA,
my lord.
if they are not filing, we'll have to take. We cannot take back. Either we reject it or accept it. That is a different issue.
Lord, I will press by my lord. If my lord allow me 5 minutes to read the impugned judgment, my lord.
No, we will not read the judgment. As simple as that. The moment we read the judgment, that is not a case in a first appeal. We'll see the evidence. The vital evidence is the eyewitnesses.
I witness, my lord. Truly, my lord.
Next, your conduct.
My lord.
If the fact is established that you were doing what that has been alleged,
My lord.
and in the process 3 persons injured, so presumption will be against you that you have done to the 4th person also.
Yes.
What is your explanation?
Well,
What is your defense case?
my lord, pass, my lord. Pass,
You
my lord.
cannot say that there is no eyewitness, therefore there is no murder.
Yes, sir. Circumstantial evidence is also there, Lordship.
If there,
Sir,
because the other person, your allegation is that you started randomly cutting the people.
my lord.
5 people injured.
My lord.
Death injuries are there. They are saying that this man has inflicted the injury. Medical report corroborates. So your action at that place is established. If that is established, why not the other presumption? What is your explanation? Now it will shift to you.
No, my
You
lord.
have to explain the situation.
My lord.
How she has died.
Yeah, my lord. I will, my lord, humbly explain it in 2 ways, my lord. Pass, my lord, the submission, my lord, my submission, my lord, the conviction under 302, my lord, is circumstances is my second leg of argument, my lord. My past leg of argument in this case will be this case, total case of acquittal, my lord. In the, my lord, the law, my lord, under 84 IPC, my lord, give some benefit, my lord, to even to accuse, my lord. Now, in whole evidence, my lord.
Given benefit to accuse, you will be drunk and kill people randomly.
No.
There is exception.
This is not a case of drug, my lord. On the record, my lord, this is case of paranoid, my lord, paranoia, my lord. Clear cut, there is a evidence by the defense, evidence by the prosecution itself, my lord, since inception, my lord. Starting from 161, 164, they are clear cut case of paranoid.
Hear this. But
Very
give a
good.
date, give a date. Paper book is ready, we will hear this matter. Give a date.
My lord, Monday, my lord.
Monday not possible. Wednesday not possible. We have fixed some other methods.
Last date in-
Give a try on Tuesday. As the matter is ready, as the paper book has already been prepared, instead of taking the IA, list this matter for hearing on Wednesday. We'll see on that day.
Alright.
Let me read
Yes, your lordship, and call for the LCR, your lordship.
LCR. huh?
After receipt of the LCR, your lordship, the victim.
I have marked it. Yesterday I passed some order. This flag mark. And the numbers I have given. This is an appeal from J. You see, I passed some orders yesterday. This flag mark is given note, Bomdila PS case number, one of them, blue notes. Admit call for the records.
Yes,
Issue notice
yes, your lord.
Notice may be issued.
to the respondents as so and so. Public prosecutor accepts notice, no
Yes.
formal
Amicus
notice.
curiae.
After receipt of the LCR,
Yes, your
registry to prepare a paper book and serve it to the
amicus.
learned,
Amicus curiae.
legal aid council.
Amicus.
as well-
Amicus, your
And
lordship.
the MF.
amicus as well as to the
PP.
learned additional public prosecutor and to and the learned public. prosecutor.
Yes, that's it.
Singa.
Yes.
Oblige, your lordship. Here also, your lordship. This is 302.
Now what to do? The notice cannot be served.
Your lordship, perhaps LCR is also not received.
LCR not received.
Your lordship, let the LCR come, then on LCR we'll find out, your lordship.
Okay, okay. The LCR call for has not been received. Registry to issue reminder and list after 4 weeks.
Yeah, deeply obliged, your lordship.
There is a report that could not be found. So address may be,
Yes, we can find out from the
then
LCR.
will, after that we'll do it.
Deeply obliged, yeah.
Item?
May please
Yes,
allow.
respond number 4.
Yes.
My lord, I filed my objection
You are filing.
regarding consideration of delay, my.
Yes, who is respondent number 4?
Under respondent 5, my lord, the writ petitioner, my lord.
Now delay of,
Delay of
200.
yes, what you
context.
say?
Now, my lord, there is no explanation in the delay condemnation petition, my lord.
Will you file an objection or will condone the delay?
I have already filed objection.
You have already filed.
My,
Where is that? What is the issue here?
my lord, in the writ proceeding, my lord, I have challenged the result notification in the year 2019, my lord.
Hmm.
And after the writ petition was allowed in my favor, directing the respondent authority to publish the result and make my appointment.
Hmm.
Subsequently, he approached after almost 2 years, my lord. In the initial writ proceeding, the issue regarding result notification, he has not challenged, my lord. Subsequently, filed a writ petition was withdrawn, my lord. That was also beyond the period of limitation, my lord. Now, writ petition he has filed challenging the issue that he was a necessary part in the writ petition, my lord. 2019, my lord, notification was issued.
Why you are necessary party?
No, he was not at all necessary party.
Huh?
No.
Why, according to you, why? you are-
According to him, that he obtained marks more than me, my lord. 2019, my lord, result notification was issued, holding that.
Who filed the writ petition? He.
No, I filed the writ petition.
Then he has not challenged that your selection.
No, he has not challenged. Now he has filed this writ appeal, my lord, challenging my.
Okay, we'll condone the delay and next
Now,
week
my lord,
we'll
yes.
dismiss the writ petition. Writ appeal.
My lord.
We are not dismissing on delay. We will dismiss next Monday his writ appeal.
My,
Okay?
my,
Can you come on Monday?
my,
Lordship in the Wednesday kindly, because
No,
I will,
Wednesday is
on
not
Monday, I will be out of station.
Tuesday.
Tuesday, all right.
Tuesday.
not.
We'll dismiss his.
Yeah.
You have not challenged, you are not agreed that you have not been selected. You have not filed a writ petition.
No, Lordship, what happened here? Because,
Tell me,
yes, I have no challenge.
You are
Initially,
you
no challenge.
obtain highest mark.
Yes,
Somebody else has been appointed. So you have no grievance. You have not challenged that.
yes.
Now he files a writ petition saying that I have not been wrongly deprived, result is not declared. He has been now directed to be appointed. Now we are aggrieved.
Lordship,
Isn't it?
matter is little
Okay.
bit of difference. Anyway, within a time
Okay,
of hearing,
but,
I will clarify entire.
No, first tell us,
Yeah.
you participated in the selection,
Yes,
you
Lordship.
were not selected,
He is not selected. And he also not selected, Lordship.
huh?
He also not selected.
But he approached before this
What
court,
happened, Lord, APC,
he approached before this court.
yes, yes,
first
yes,
ever
Lord.
grievance.
yes.
His repetition is allowed, now how you are interested?
Uh,
How will he know that you are
What-
getting more marks and you have a grievance?
Lordship, Public Service
You will have
Commission
to,
has,
you will have to come to in his sleep and in his dream, you will have to tell him, no, I am also heard the learned counsel for the applicant. This is an application under section 5 of the Limitation Act 1963, paying for condonation of delay of 201 days in filing the connected writ appeal. Filing the connected writ appeal. Full stop. The writ petitioner respondent number 4 has filed an objection to the condonation of delay. Consider the arguments advanced by the learned counsel for the parties. The delay has been explained at paragraph
6, 7, 8 and 9, Lordship.
6, 7, 8 and 9.
Yes, Lord. It is on medical. ground.
At paragraph 8. In as much as it is his case that the writ appellant has been seriously ill and we're suffering from severe jaundice and we're undergoing treatment. Considering the above, the delay is condoned. The writ appeal will be listed for admission on Tuesday, next Tuesday, showing the name of the respective councils representing the respondents.
I'm for
Offline,
number
Lord.
5.
Huh?
Respondent number 5.
Respondent number 5.
Offline.
Offline, Lord.
IS stands disposal.
Please, Lordship and Ladyship, there is a practical difficulty in the sense we have already partly rehearsed the final arguments and Justice Bothakur's bench had to release it because of shortage of time. And I see the same problem today also. So if Lordship and Ladyship may be pleased to list this matter when we have a continuous 2 weeks of the bench,
I
firstly.
think you will get that on 28.
That is, I'll have a personal difficulty because I'm out of country. I've got my meetings in the UN. So if we can have it sometime in December.
Give a date as per your.
Lordship, the bench is not on because 4th December onwards, there is the bench of justice, which is for the week of 4th December. I'm okay for this week and the next week, if the same bench continues. Because,
We are now, the same bench is not likely to continue.
so that's the whole problem, Lordship.
As
And
per roster is not likely to.
that is the whole problem. Or Lordship may be pleased to, fix a day when we do this item through the day, because I'll take a good 5 hours. And my learned friend will take, I think, 2-3 hours.
Maybe.
Yeah, and then 1 hour for my rebuttal thereafter. So we need if that can be accommodated, that will be wonderful, Lordship.
You give a date as per your convenience. Because roster, we know for this week and next week.
Yes,
Thereafter, we are not.
that is the whole issue, Lordship. So, we don't know what to do, and that's why I'm just keeping it.
We are
Vicky
fixed.
and myself, we were
Let
discussing.
it be in the new year.
I have no issues.
Huh?
I have no issues.
No, I'm good. I'm good. January, I'm available entirely. So no issues.
Give a date.
But again, Lordship, the division bench days also changes. Sometimes it's Monday, Thursday, sometimes it's
But
Tuesday.
that problem we'll have here. No problem. No
So
issue.
I was requesting Dicky, I said, let's file an application before chief in Guwahati. And if you come along, I'll tell the government to pay your airfare also. Come to Guwahati, let's do it.
You file an application, we are just giving a date. In the meantime, you can file an application, definitely.
If my dear friend agrees, I will pay his airfare. I'll tell the government to pay his airfare. No issues on that. But this matter, it needs to be decided also.
Precisely we decided.
Yes.
Because it's issues, both are, this is the issue regarding the shifting of this pensions.
Yes. And
Anyway,
there people are.
Anyway, give a date.
Lordship, we can have it in the week of 4th to 8th December, 11th to 15th December, if the bench is continuous. That's one.
That we are not, that is the prerogative.
So
of-
I will coordinate with
Okay, you have a coordinate.
with Santosh and ask him what the benches are.
Yes.
And maybe Dicky and myself, we can coordinate and then
You do one thing, we are fixing this in a week. You make a mention and get it listed.
yes,
You
that
can-
will,
Okay.
we'll see the bench and
List this as agreed to by the learned council for the parties. List this matter in the first week of December.
first week of December, yeah.
First week of December with a permission to make a mention for listing in a fixed date by the learned council.
Yeah, that will be really obliging,
I was
Lordship.
giving the option. if
Yes,
you
yes.
can make a mention.
Deeply obliged, Lordship, deeply obliged. So we'll work it out amongst ourselves and we'll get it. Deeply obliged and ladyship, thank you.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 10. Lordship, I have taken consent from the petitioner also, Lordship. I'm making a mention on behalf of Mr. Tamar Gadi, who is the standing council RGU.
Lordship, no problem, Lordship. Affidavit, not final still, Lordship. Affidavit is required for State
Lordship.
Council, Rajiv Gandhi University.
From standing council,
RGU, Lordship.
RG,
RGU, Rajiv Gandhi University.
Rajiv, item number 8.
10, Lordship.
10. That is what I say. RGU is important because he just give
Yes.
payment of enhanced something promotion like
Retrospective.
assured
effect
scheme.
promotion, Lordship. Yes, career advocacy scheme. Lordship.
Yes. The affidavit on behalf of Rajiv Gandhi University has not yet been filed, which is necessary for determination of the present case. Full stop. The learned standing council on learned standing council for the RGU praised for and is granted
2 weeks. No problem, Lordship.
2 weeks time to file the affidavit in office. Yes.
May I, Lordship? Lordship, I would like to mention item number 16, Lordship. 16, Lordship. Lordship, I taken the consent from other side, Lordship.
16, 17, 18.
Yes, Lordship,
suspension.
16, 17. he's the
17 and 18, I'm representing.
Lordship, this matter may be fixed for, Lordship, fixed on 21, Lordship.
Is it for, this is a suspension?
Yes,
You are
Lordship.
still under
Yes,
suspension.
Lordship.
Fixed for when?
21 of this month, Lordship.
21st, okay.
Much only.
As per for the learned council for the petitioner. The matter stands adjourned and be listed on 21st of November 2023.
Much only.
May your lordship, I beg to mention item number 25. For the petitioner, your lordship, I have taken the consent from the opposite
Okay,
party.
okay.
May I pray that this matter may be listed on 19th of December, your lordship,
19th of December, Monday,
Monday.
okay. As prayed for by the
19 is Tuesday, your lordship,
Tuesday,
your lordship.
okay.
December, your lordship.
Okay, 19th. You are on behalf of?
I'm for the petitioner.
You are for a petitioner. On the prayer of the learned council for the petitioner, the matter stands adjourned and we listed on 19th of December 2023.
Obliged.
Yeah, my lord, I may be allowed to mention item number 20. I'm on behalf of Mr. Dilaji, who is representing respondent number 13 and 21.
Hmm.
Due to his health condition, so this matter may be fixed after 2-3
You are
weeks.
for a petitioner on behalf
No,
of
I'm for the respondent,
respondent number,
13 and 21.
but what about respondent number 9 and 10? Take
I
up
have,
steps.
I
You are
have
for a
taken,
petitioner.
I have taken a step.
No, you have taken steps, but 9 and 10, who is for a petitioner?
I am for a petitioner and I,
But 9 and 10 answered, take fresh steps.
okay. So well, in that case, my lord, might be allowed to take dusty service.
Okay. Office note dated 8/11/2023 reflects that the notice upon respondent number 9 and 10 has not yet been served. Full stop. in view of that, the learned counsel for the petitioner submits that he may be permitted to take trustee service in respect of respondent number 9 and 10. Prayer is allowed. However, the same should be routed through the registry of this court and an affidavit be filed after service. Full stop. List
Okay.
after 4 weeks.
Obliged.
May I please, my lord?
Yes.
Item 19, my lord, I was supposed to file affidavit, so I need some more time to file affidavit. So 2 week times may be given. I have taken consent.
Okay. You are standing counsel RWD.
RWD, yes.
The learned standing counsel for RWD prays that he may be granted 2 weeks time to file affidavit in opposition. Full stop. Prayer is allowed. List accordingly. According to him, notice has been issued.
Yeah, notice was.
Deems service. What is your sen? You just explain it. Okay, deem VRS. Already your date is over, September 23rd, something like that. Yes, anyway. Okay, that's okay.
Because some case is pending, so we want to bring it to the record.
Okay. You want to say that to avoid those you want VRS. Okay. Next.
Publish.
How this is maintainable?
My lord, FIR was filed before.
You have filed FIR that has not been registered. Go to the special judge under section 156. Huh? Under section 156.
My lord, the authority, state authority.
There is a recent judgment specifically saying, then don't entertain this kind of writ petition. Let them first avail the opportunity of the provision under section 156 going to the magistrate. Here the magistrate will be the special judge. Go to the special judge that this is the affair, I have lost it. And there is a bar, specific bar. What is the judgment? Recent judgment. Very recent judgment.
Then I'm not aware that the Justice Kajju's judgment is also there.
Specific bar.
My lord, the state authority is also involved.
We understand state authority is involved, therefore you have directly filed an application before the director CBI. Okay, come prepared on Monday. This is not a case to be entertained. CBI, what is the judgment?
Well, I'm sorry, my lord, I am not aware of the judgment.
My brain is gone.
My lord, otherwise also, as per the CRPC, my lord, if the.
No, CRPC is there, but earlier we used to entertain this kind of petition. We used to entertain earlier. But recently now the law is developed that please do not exercise your 226 power. First let them go to the magistrate. Because there is a specifically magistrate is empowered if affidavit is not registered. Even now the law is developed to that extent that when you file the petition before the magistrate, that is to be supported by an affidavit. Specifically saying that we went to this that has not been registered. If that affidavit is not there, then even the application filed under 156 before the magistrate is liable to be rejected. That has been because many false cases are filed straightly, not going to the police, coming to the magistrate. Monday.
My lord, order may be.
Then we'll dismiss right now. Come prepared.
Otherwise, it will take
If it would have been in Guwahati, I would have dismissed by this time. It will take 5 minutes to open my laptop.
tomorrow.
Not tomorrow, Monday.
My lord, I may be allowed to withdraw.
Huh?
I may be.
No, don't withdraw. Why you withdraw? Let us see what is what. You do not know about the provision you have come and you will withdraw. The judge says, judge may be wrong also. Come prepared on Monday. Okay? Let us see what is your preparation. On the prayer of the learned counsel for the petitioner, release this matter on Monday.
And I'm sorry, my lord, on Monday I'll be having some personal difficulties. So, my lord, by
Tuesday.
My lord. Developed.
Item number 2, I'm extremely sorry, my lord, I missed it. Can it be taken up some other day? I did not figure out.
Okay, no, there are some service 2-4 office notice there. There is a mention memo therefore listed. What was this? You are for respondent.
Yes, sir, respond number 11. Any other day, my lord, I will.
Okay, next week, any date? Give a date. Mr. Panging learned counsel for the petitioner submits that he may be granted some time to some time full stop. Prayer is allowed. Please this method. Next week?
Next
any
month,
date?
yes.
Thursday?
Right.
Next Thursday. None appears for the petitioner on call. None did represent the petitioner on call when the matter was listed on 5/10/2023. The order dated 38/2023 reflects that Mr. A. Saring, learned counsel for the petitioner, submitted before this court that due to change of circumstances, he has informed the petitioner that he will no longer be able to represent them. Full stop. Accordingly, matter was adjourned to enable the petitioner to make an alternative arrangement. Full stop. Thereafter, nobody has represented the petitioner on 5/10/2023 and today. Full stop. But this is not a way to withdraw a case. You have to issue a notice. Give it to the registry. Nobody for private respondent also. In the aforesaid view of the matter, registry to issue a notice to the petitioner with a copy of this order. Full stop. The petitioner may, after receipt of such notice, petitioner may engage new counsel. Otherwise, this court will be left with no alternative but to dismiss this petition for non-prosecution. This after 4 weeks, 6 weeks.
Yeah, my lord.
Yes, what is your case?
My lord, for non-payment of compensation for value of land and solution with interest. Yes, my lord. May I? So what happened, my lord, for construction of BCT road, Balipara Chardwar road, my lord.
Do you dispute about the deceased report?
Report, no, my lord.
Huh?
No, my lord.
You want your compensation as per Deputy Commissioner's report?
No, my lord. Compensation has been assessed for my house property, my lord, not for value of land, my lord.
So according to you, there is a report from the Deputy Commissioner.
Yes, my lord.
Which says that your land compensation is not calculated. And they have calculated certain amount.
Yes, my lord. For my house property. My lord.
Only that much you want, not above that.
I want compensation for value of my land, my lord.
Now,
The house property was assessed, my lord, but not the value of land, my lord.
Yes, what you say, this is an admitted position.
As per our affidavit, my lord, for respondent number 1 and 2, my lord. Our contention is, my lord, the compensation amount, the handsome compensation amount. Has been already
No,
paid.
it's a handsome or non-handsome, not the issue.
My lord.
Whether that handsomeness includes the land. he will be more handsome.
Yes.
The compensation will be more handsome if the land is
As
not
per the
taken.
assessment done by the district administration, my lord, we have accordingly released.
Now dispute administration says, oh, sorry, we by mistake, we have not even calculated the land. So you'll have to pay it. Because he wants, his handsomeness is not full till now. Yes, Deputy Commissioner.
Lordship, since this very award is now being disputed, Lordship.
No,
Because that was given to the petitioner a long time back, Lordship.
No, whatsoever. There is no dispute. He is not saying, that's why I asked put him the question, whether you want whatever they are, they have assessed and they are finding. This is the finding of you, Deputy Commissioner, that yes, land was not incorporated.
That's admitted position.
If it is admitted position, pay it, that's all. If you say that no, it's paid, then we cannot entertain a writ petition. Yes, you will have to pay. If it's by mistake, it is not. And Deputy Commissioner is you are the acquiring authority. Deputy Commissioner is the competent authority. So you will have to pay as per assessment of the competent authority. Now, competent authority says that no, there was a mistake on my part. Land was not calculated. This is the value of the land. Pay him the value of the land. Where is the Deputy Commissioner's report?
My lord. That is it.
Until and unless you challenge the Deputy Commissioner's report, say that no, this is we have paid for land, this is a mistake, or you have taken, it's a collusion with the petitioner, that we do not do.
Nothing is in,
that is not your stand. You said that we have paid as part of whatever Deputy Commissioner told us that this is the compensation, we paid it. Isn't it?
Yes, madam. But another point is whether the assessment done by the district administration has been duly communicated to the respondent number 1 or not.
That may be an issue. That may be an issue. Yes, whether it's communicated, you have that instruction, we are taking up next week.
Yes, madam.
And we are passing an order.
Therefore, in our affidavit, there is no whisper about the regarding the press assessment done by the district administration.
Take down. The present petition, the land and private house of the petitioner was acquired for the purpose of construction of two-lane Trans-Arunachal Highway from Balipara, Sarduar, Tawang, which passes through Dirang Circle. Full stop. The petitioner's house was situated near Dirang.
Yes.
What was the village?
Dirang village.
Dirang village.
Yes.
Was situated at Dirang village. Full stop. The value of property was assessed to be 23,41,580 rupees, and same was paid on 16/4/2012. The basic grievance of the petitioner is that he has been denied solicium as required to be paid under the provision of 2013 Act, but your payment was prior to that.
Land and solution.
Land, solution
compensation
is
for value.
2000 fair compensation. Your acquisition is prior to that. Award is prior to that.
Yes, sir. 2012, 30% solution I've entered.
Okay. Solicium under which act?
Section 23 plus 2, madam.
Of
1894, madam.
It is 1894 or Balipara.
1894, madam.
Acquisition was 1894.
1894, yes.
Under the Land Acquisition Compensation Act 1894.
Yes, ma'am.
The further grievance of the petitioner is that while assessing the compensation, the value of land was not incorporated.
Yes, ma'am.
Full stop. So far relating to the value of the land, the Deputy Commissioner and the competent authority, namely the Deputy Commissioner, West Kameng District, submitted a report on 13/9/2020, is that it?
Yes, my lord. This
Where
is
is that page?
page 75, my lord.
Huh?
Page 75, my lord.
Page 75.
Yes, my lord.
Wherein it is admitted that while calculating the compensation, where is that paragraph?
My lord, paragraph 4, my lord.
Hmm. Wherein it was admitted that while assessing the amount, solatium as applicable to the land value under Land Acquisition Act 1894 was entitled what was rejected. Entitled per solatium of 30% was rejected. Now, where is that admission that your land value has not taken?
My lord, page 74 is the board decision.
Huh?
Page 74 is the board decision.
Comparison. And the decision of the board constituted pursuant to order passed in WPC number 107 AP 2022 has where is that? Where is that?
Well, para 2, my lord, as per the assessment report, the petitioner owned so and so, house so and so was estimated for the property by the board. And para 4, your honor, adhering to the LAX so and so was estimated as solution for the property of the petitioner, nil amount was so and so, and other in the stage of BCT road.
No, where do you say that you have made a statement in the pure pleading that Deputy Commissioner has admitted that land value was not counted? Where is that?
Para 4 of their affidavit, your honor.
Para 4
of in WP
no. In the writ petition itself, you have said
yes, madam,
that Deputy Commissioner in his report has admitted
yes,
that his land, while assessing the amount,
yes,
land was not land value was not calculated.
Yes.
You made a statement. Where is that?
yes, sir. My lord, para 4, madam.
Read it.
Adhering to the LA Act 1894, nil amount was estimated as solution
Okay.
for the property of the petitioner and other in the stage of BCT road, and 30% lump sum solution was applicable only for land value as per the LA Act 1894, which was in effect during the estimation of compensation by the compensation.
But what does it mean?
It means, my lord, the land, the solution only, my lord, is applicable to value of land, my lord.
So where is your findings that value of land was not calculated?
My lord, para 2, my lord, of the board proceeding, my lord.
As per assessment report, petitioner owned only SPT brick house, so and so square meter. Compensation was
For the property.
For the property.
Yes, my lord.
By the board, property includes the land.
My lord, in that case, my lord, your lordship may please come to page 35, my lord. This is the first assessment, my lord.
Difficult. If you make such kind of statement, we don't see all the papers.
My lord.
You made a specific statement.
Yes,
admitted.
This is the valuation, my lord. Valuation of house property on BCT road, my lord. House property only. Page 35, my lord. Page 35, my lord.
Page 35, okay.
Yes.
Yes, what is your stand?
Lordship, see the paragraph 6 of my opinion.
Even in the paragraph also, my lord.
At page at page 6 of my affidavit. The second paragraph, as per a roll of payment made in 2012,
Affidavit filed by
filed by the respondent number lordship.
4 and 5.
4 and 5.
4 and 5 paragraph.
Page 6 lordship, paragraph 6, the relevant paragraph is at page 6 lordship.
Page 6.
If second paragraph.
That with regard to the statement made in paragraph 4 starts with.
Yes, lordship.
Ah.
But next page lordship,
Okay.
the second paragraph, as per the a roll payment made in so and so. So for this amount of 23,41,580 is concerned, this is for the house property only, lordship. That is the admitted question, lordship.
Property and building was done between so and so, so and so. So you said that this is respondent number 4 and 5.
Lordship.
Mickey Boje.
Yes.
Isn't it?
Yes.
Which paragraph you are saying?
Paragraph 6, lordship.
Paragraph 6.
Paragraph 6. This is replying to paragraph 4 of the writ petition, lordship.
Hmm. There is no admission that land was not compensated.
May I, my lord?
This was paid in the year 2012.
12. Yes, my lord.
We'll admit this matter. You don't have any case.
My lord, may I?
We cannot decide all this disputed.
No, my
You
lord.
made something else in the pleading and your records
No,
are
no.
something else.
My lord, may I clear, my lord?
Yes.
Item number 5, my lord. Same, my lord, same issue, my lord. WPC number 309, my lord. 309, I have filed, my lord. Writ petition, my lord. Seeking solution, my lord. Seeking solution from my house property, my lord. In that, they have stated, by this order, they have rejected my prayer for solution by stating that the value, solution is applicable only for the value of land, not for the house property, my lord. Because of which,
So
my lord,
meaning thereby your land was not assessed.
Yes,
This
my lord.
is your interpretation.
Yes, my lord. And
Not
then,
admitted position that no land was assessed. You made a statement in your pleading that Deputy Commissioner has admitted that land was not assessed. That is not the
this
case.
is the rejection order, my
We'll
lord.
hear it some other day. You have already got the we thought that you have wrongly been denied the land compensation.
No, no, my lord, this is the rejection order.
We'll see. Pleadings are complete. Admit. Please this matter for after weeks. Now we'll have to come reading from page 1 to the last page. How many meters are there? No, this I'll take up this method first. First, yes, option is yours, Dicky. We'll take the APSC first or the 10, 11, 12, 13. 10, 11, 12, 13 will not take much time.
May I, my lord? My lord, I am appearing in item number 6, which is led by Senior Counsel D. Mazumdar.
We know
In the last occasion, Your Honor, we have requested to this honorable court to accommodate date for 15. Since this honorable court has due to urgency, so we are not we are also not wanting to adjournment. So matter maybe if this honorable court permits through VC, so that D. Majumdar
Yes,
may.
of course.
Yes, tomorrow VC tomorrow. So today.
Yes, what is your problem,
Item-
Mr. Chaudhary?
If necessary, because every minute's delay, we are without a commission.
This is a good proposition.
Yes.
Because see, I think Dicky has told you.
My friend can start. I will also address. Let Mr. Mazumdar address to VC tomorrow. If necessary, I will stay back.
Yes.
No, you need not stay back. You will also, you can also do it through VC.
In any case, I will not be able to attend court in Guwahati. So I have come prepared to stay back if necessary. So no, not a problem.
Okay, issue is this, suppose if we delay it to up to 15,
It will be,
for me it will be
It will be-
difficult.
so this is the ideal proposition.
Ideal proposition.
So my
Let
friend
us-
Mr. Panging can start, I will address your lordship. And Mr. Muzumdar can address tomorrow. And if necessary, I'll give a reply right here.
And
we'll
I
finish
think
off.
this is also live streaming is going on. So
Yes.
Mr. Mozumdar can download to this live streaming or he can
Yes,
look
yes.
into the live streaming, what is the argument?
In fact, my lord, we will be today submitting the written argument. And in that line only, it will take
Very
30
good.
minutes.
Very good.
So I will serve the copy to
In that
the,
case, everything can be finished by tomorrow.
yes, yes, without fixing the,
Tomorrow we are not taking a risk.
No, but
We'll-
today
we'll-
itself it can be.
We'll take a call on Monday.
That is also understandable, not a problem. And in any case, by coincidence, Monday again, I am supposed to be here for another matter. So, no problem. So let Mr. Panging start.
Panging start. Now, before that, Panging is having a series of matters. So let us then complete this. Only these matters are left.
Yes.
Isn't
Your lordship
it?
can finish off the other miscellaneous matters and then start
Start, yes.
before the supplementary hearing.
Yes. Now, supplementary hearing today, we do not think anything will happen.
So your lordship will-
Already 3 matters are there. One is adjourned. And 2 matters are there. One is, of course, of 2017.
The photos method, man, we can take it next week. We should, but I already had a chat with my brother, man.
Okay, item 24.
Next.
So many matters have fixed next week, thereafter, not next week, not all this.
My lord, I'm also leaving for Delhi next week, my lord. Can it be somewhere in any date in December, my lord?
December.
Any
Give a
date.
date.
Any
4th
date.
of December.
4th of December. Very good.
As agreed to by learned council for the parties, list this matter on 4th of December. 25 already gone, only left is 26. This is 24. 26,
Next week, my lord.
not next week, that it is also
Yes.
again 4th of December.
Yes, ma'am.
4th of
4th of
December.
yes, ma'am.
Okay,
I am submitting written argument.
just a minute, we'll come to your case a little bit later. Okay. Now. Now calls, except 6 and 7, call the other matters. Eight and 9, somebody sought for some adjournment, isn't it?
No, Lordship.
Huh?
No.
Morning?
No, Lordship.
Huh? Huh?
No, Lordship.
No, no, okay.
Yeah,
We have already been evicted.
They've been evicted and their property has also been demolished. Although if they've approached this honorable court after the demolition of their property.
After demolition, you approach the district court also, appeal also.
Yes, Lord.
Appeal also stands dismissed.
That is all.
My lord, that land, my lord, it is admittedly government land, they have undertaking that they will be vacating, and that on the undertaking, they were allowed to reside there in the government land. Now, series of, there's no NFA, but it was ultimately the area meant for the construction of.
Do you dispute that it's not a government land?
Yes, yes, Your Honor.
Is it-
Because the
She's under-
petitioner was posted
Who
under
are you?
the.
My lord, I'm at the medical department. my lord.
And you?
Deputy Commissioner.
Deputy Commissioner. Nothing is there.
The,
Court.
the notice and the orders itself is illegal because no hearing
What
was
will you-
conducted. So in such a situation, if such an order is allowed to exist, Your Honor, it will.
You want a restitution of your possession.
That will happen before the lower court, before the civil court. And in
Ah.
order to do that, these impugn orders and notices need to be quashed because on the basis of these notice and orders, they are pursuing construction against the petitioner's land. And he has been he has been in possession of the land.
Where is your document, land document that?
The LPC is under process, Your Honor. It has not been issued.
How can there be if LPC is under process? This is not your land.
However, he has been in possession and even the respondents are not denying it.
Possession will not be, lands belong to whom?
Even they cannot prove that, Your Honor. They have not given any map or even the medical
No,
department
no.
does not have
Is
any
it-
allotment.
Where is that notice? First notice?
First notice is at page 24. Annexure 1, page 24.
You are a government servant,
Yes, Your Honor.
having in a quarter and now you want to continue.
Not a quarter, Your Honor. There is no such document that they have produced or exists, because even through the RTI that the petitioner has applied for, the RTI did not provide any LPC or land allotment that was under the medical department. And recently, Your Honor, we've been updated that there is a portion of the land, the same land that is under dispute.
Where is your reply to notice dated 17th of April?
Page 49. Page 49, Annexure 10. Even in the reply, the petitioner has clearly stated that the RTI does not include
Page
any map.
49.
There were electricity bills also which were enclosed.
Oh, forget about electricity.
My lord, we have enclosed all
Just a-
detailed document.
Where is the
Finally, please.
Tell me, where is the decision of the appellate authority?
That we have not received yet.
Huh?
That we have not received yet. The appeal was also not taken into consideration.
No. Have you filed any appeal?
Yes, Your Honor. Appeal is at
Appeal is at page
page
63.
63.
Where is the decision in the appeal?
They have not passed any decision. They've not conducted any hearing on the appeal as well. Completely ignored it.
Yes, Deputy Commissioner, what about your decision on the appeal?
And even the affidavit is silent on it.
This is a substantive valuable right. Yes, what is your answer on that? Page 63. Necessity of the petition. Hmm? You cannot do your homework here.
My lord, this, the appeal, my lord, it was filed after eviction, my lord.
Maybe.
My lord.
Dismiss it.
My lord,
Give
my
a
lord, right,
reason.
right.
Where is that?
Lordship, as per our affidavit, it has not been disposed.
Where is, what is the stand? Read your affidavit.
It's in page 6, Lordship, 11.
Read it.
It's regard to.
What is going on? Is it a procedure?
My lord. Paragraph 15, the answer offers no comment at this matter of record. So that means it implies that still pending.
Take instruction.
Give me the act. What is the provision? Any provision of evidence and sons given to you?
Eviction should have taken place in accordance with Section 4 and Section 5 of the Arunachal Pradesh Public Premises Act. According to which, Your Honor, specifically in Section 4, Clause B, it requires that all persons concerned, that is to say, all persons who are or may be in occupation of or claim interest in the public premises to show cause, if any, against the proposed order or on or before such date as is specified in the notice, being a date not earlier than 10 days from the date issued thereof. Even with this regard, we've only been
You have
provided
obtained
7 days
instruction.
time.
What is the status of that appeal? And don't pass an backdated order. It will be heavy on you. We are telling it. Monday.
Your Honor, under this, initially
See,
on the
appeal
first
is
day,
not decided, then we will remand the matter to the appellate authority. And we will specifically observe that it will take all the grounds you have taken, consider all the grounds you have taken in your appeal, and answer all the queries you have raised, all the questions you have raised.
yes, sir.
Okay.
But in the meanwhile, Your Honor, they are constructing currently in the property.
My lord, that is project, my lord. We are upgrading that earlier it was CH3 donated by the public, my lord. And there we are upgrading it.
Have you filed all this on record?
My lord, we have.
Okay, you take a stand on that.
My lord.
The present writ petition is filed assailing an order of an action of eviction under the provision of the Arunachal Pradesh Public Premises within bracket eviction of unauthorized occupants bracket close Act 2003. Full stop. The petitioner, according to the petitioner, he or she, petitioner had already preferred an appeal under section 12 of the Act 2003 before the appellate authority against such action on 21/6/2023, which has not yet been decided by the appellate authority. First of all, the learned counsel appearing for the appellate authority, that is the deputy commissioner, has fairly submitted that no specific stand has been taken in the affidavit regarding the fate of such appeal, which was filed before the appellate authority. In that view of the matter, let an instruction be obtained by the learned council by the next date fixed, whether the appeal has been taken on record and any decision has been taken. And if no decision has been taken, the reason thereof. Full stop. List this matter on Wednesday.
Unless it could be
When
fixed on Monday. If it could be fixed on Monday, because they are continuing with the construction.
No, Monday may not be possible. You have fixed too many matters. Or Tuesday. Tuesday.
Monday, Monday. Wednesday.
And you're right.
You have waited so many, no interim order was there. And public project, you can be compensated. Suppose we hold that it's wrong. We set aside it. You will have to seek a declaration from the civil court. Then if a declaration is given, you will be entitled for compensation. Otherwise, your land, suppose you are a owner of that land, that can be taken by acquisition.
Yes.
So then you will be entitled for compensation. So therefore, a public project is not to be halted since you are having some alternative remedies.
However,
Even
they
if
are
we-
not, they have not been successful in showing that that land belongs to the
No,
department.
no, your basic case is the RTI.
Yes, you're
In RTI reply, they said that this their land is something different. If you can establish that before the deputy commissioner, it's well and good. If you cannot, then again you'll have to come before this court. If we decide in your favor, because if we remand back it to the deputy commissioner, will specifically mention what is to be decided.
Yes, sir.
Okay?
Yes, sir.
Then deputy commissioner will decide with a specific period. And if it is finally, if you are the legal owner of that land, you will be compensated. Otherwise, your land can be taken for construction of a hospital.
And you're right.
You take back the. No DP.
No. No memorandum of charges, nothing.
What is it?
In fact, they know we are not even remotely connected.
No, will not go to that merit. Where is the first order of suspension?
26, my lord, page 26. Page 26. This is by the Secretary Public Service Commission. The first suspension order was not by invoking the provision of the CCA rules, but Article 371H.
How 371 is related to a joint secretary?
This order itself is my lord.
Okay, then thereafter.
Thereafter, on page 27, my lord, all the petitioner, including others, were transferred to the cadre of the civil secretary. In the interest of public service, the governor of Arunachal Pradesh is pleased to order merger and encadrement all of the group A, B, and C posts born under the establishment of Arunachal Pradesh Public Service Commission into the common cadres of Arunachal Pradesh Civil Secretary. So we got transferred there. Thereafter, my lord, the extension orders are issued under the CCS rules by the Chief Secretary, my lord, at page 30 onwards.
Page
30. This is the first extension.
Suspension was on 29th of October 2022.
My lord.
Now, October, November, December, January. Okay, 25th of January.
25th of January. This is the first one for 90 days. 90 further days. Then, my lord, page 32, 25th of April, another 90 days. Page 32, 90 days. Then the last extension is, my lord, 24th of July, page 33.
And thereafter, nothing.
Nothing. My lord, they have filed an affidavit stating nothing, but they have enclosed the amended CCS rules. Even in terms of that also, it is, I can be suspended only for 270 days. 365 days more over now.
As per that rule, you can be suspended for maximum period is
70 days.
So 270 days. That is
More than-
also over.
That is also over. And Ajay Kumar Chaudhary security covers it.
And there is no extension after this 24th
No,
July.
no.
No statement. Anything? Huh? Extension.
Yes, sir.
Where is that?
Lordship,
No, 24 is the last one.
24th of July 2023.
it has been extended up to Lordship 26/7/2023, Lordship. Thereafter, it has been extended again, Lordship.
When? Where?
Just I have been told, Lordship.
Huh?
I have been told. Lordship. It has been
So if you haven't talked, have you been served with
No,
anything?
I have no instructions on that.
Let them be reinstated.
Lordship. Lordship, basically, the reasons for the extension, Lordship.
Huh?
Region-
Only for the extension.
Yes, yes.
Extension and no departmental process.
No.
Even extension cannot be up to this
Yes.
to unlimited
Yes.
period. Even your rule says
Yes, yes.
that
270 days.
200.
270 days.
Now how many days is passed?
More than 365, madam.
First suspension is October 2022.
No, yes, it's going to, it's November 2024. Three now.
So and what about the other cases?
Other cases up to item number 14, exact same dates.
Same even annexers.
Yes,
Same.
yes. Item number 15 a bit different.
Item
There, my
number-
lord, they did not even extend the extension was not in time.
This is item number 11, 12.
11, 12, so up to 14, my lord, all same orders.
All same.
Same annexures.
11 to 14, all same.
Yes.
Then what is about the 15?
15, my lord, the difference is the rate. First two is same. Page 27, my lord. This is the same order, 29th of October. Then, my lord, the second annexure is also same. But the first extension is at page 30, my lord. So
Page 32.
32. It was,
It's 22nd.
that was 22nd of May.
Now, what is the first date of suspension?
29 October. They did not review it within 90 days.
29th of October, 15 to liquid. Date of suspense, first suspension is 29th of October 2022. No review in the meantime.
Yes,
First review is on
this 22nd May 2023.
page
32, man.
Page 32.
Yes.
First review on 22nd May 2022.
23.
2023. That is after
More than 6 months.
more than 6 months
Almost 8, man.
or 6 months. Thereafter on
And this page 33. This also, my lord, after more than 90 days. After the period was
then
over.
Page 33.
Yes. 10th August.
This is on 10th of
August.
August.
Yes.
10th of August 2023.
Yes.
Even after more than 90 days.
Yes.
This is just noted down. Dicky, you will get these orders on Monday only. Item it is 15. 15 is a little bit different. Others are same. And give that amendment. You have annex.
I have annexed in the
Annex.
annexed in my opinion.
Annex in your
Annexed.
affidavit. I've seen somewhere that these rules, 3 provisions
Yes,
are
yes,
amended.
yes, yes.
Tense.
I can be only under 270
Okay.
days.
And what was the citation?
2015, volume 7, SCC.
Just write it down.
291.
Volume
15, volume 7, SCC 291.
291 and which paragraph you are relying on?
21.
Paragraph 21. Okay.
20 and 21.
20. Read petitions stands allowed.
I do.
একটু আইসে না আমার number. Yes.
Non-compliance of order dated.
Now tell us, who is the education department? Please tell us, what is your decision?
My lord, actually, we have found, my lord, after this, after the judgment, my lord, there was a communique from department, my lord, to the APCS that this gentleman, the petitioner, is not the person who should have been appointed, my lord. In fact, if this decision of this honorable court is applied, my lord, beneficiary would be someone else, my lord, who has secured higher than the petitioner, my lord.
Okay.
Accordingly, my lord, we have filed this review petition before the registry, but is yet to be listed, my lord. And your lordship has instructed me yesterday that in that case you should go for this partial. Yes. That part we my lord, we make the endeavor this morning, and we discussed to the this registry part also. They have given us our civil review petition number 13 of 2022, and they said we should make a writing today, my lord. So accordingly, we will be making a writing today, my lord.
To the Honorable Chief Justice, you write a letter.
My lord.
This is the situation.
My lord,
It should
yes.
be listed.
Yes, my lord.
That review, this is the review.
Yes, my lord.
If that be so, we'll wait for some time if review is filed.
No, my lord.
Because APSC has recommended.
My-
Now, only question is, they are sitting over the APSC decision. This is your case. APSC said, file an affidavit saying that we have already forwarded the recommendation. We have nothing to do. That part is over. Now, only thing requires is the recommendation to be acted upon. Now, they say that if they go by the judgment of this court, not you, somebody else is to be appointed.
No, my lord, direction was given to appoint me, my lord. Because now, my lord,
They want to say that the direction issued to appoint you on the basis of certain principle.
no, my lord, specific direction is there.
Yes, my lord. Certain principle. Yes, my lord.
If that principle is applied, you are not the person.
No, my lord, may I show your lordship?
Their
Page 20.
principle was, my lord, simple. There cannot be reservation within reservation, my lord. That is the principle, my lord.
Page 23, my lord. Page 23 of the.
I think there is another revision regarding.
No, appeal. The person, your lordship has just allowed the condemnation petition just now, just before in this division bench, my lord.
Item number 9, my.
Item number 9, my lord. That was the right person actually. But unfortunately, he didn't approach, my lord. Your lordship has got the matter in the crux and even cautioned him that your lordship might dismiss his case. And that was absolutely right, my lord. He should be the person who should have filed this writ petition, my lord. Now, his inaction has landed me into trouble, my lord.
Okay, we'll adjourn this matter. When is the matter is fixed?
On Tuesday, my lord.
Tuesday.
May I submit one thing, my lord? My lord.
What you want? It's a contempt. Will be sent him to jail.
My lord.
Can we send him to jail today, right now? Or you want a mandamus in a contempt? Say yes. Okay. On the prayer of the Learned Council, Learned Standing Council for the Education Department, matter stands adjourned and be listed after a week.
Okay.
Your lordship.
Yes.
Earlier, this court has directed me to serve the notice to the private respondent 4 and 5, and we have served the copy to them.
You have served?
Yes, sir.
You have served how?
Through the registry. Yes, sir.
Where is the affidavit? Where is the permission to dusty? Which order? By which order you were awarded to, allowed to?
14/8/23, your lordship.
14/8/23. Registered post AD within 10 days. Service is awaited. So you wait for some time. It was issued only on September 11th.
Okay.
Okay.
Yes, your lordship.
In view of office note dated 8/11/2023. Await service report and list this matter after 3 weeks on an updated office note.
Obliged.
with an updated copy. Yes, respondent number 2 and 3, no counter file.
Uh,
Your affidavit is required.
My lord, extremely sorry, my lord, matter was listed today. I was not aware, so I did not brought the file.
Okay, now when will you file your correspondent number 2 and 3?
Yes, yes, ma'am.
When will you file it?
Within a week.
Within a week.
Yes.
The learned counsel for the petitioner submits that he will be able to file the counter within a period of 10 days from today. Accordingly, he prays for an adjournment. Prayer is allowed.
Your Worship, kindly continue the stay.
After 10 days, the interim order passed earlier shall continue until further orders.
Highly obliged.
Obliged.
Wait.
Constitution.
Yes, submitting written down.
In WPC,
Item number 6, ma'am. Okay. 223.
give a copy to the learned advocate. Which method should we take first?
My lord, item number 7.
Item number 7, that is Rosie.
Rosie.
There are 2 persons.
2 persons.
Others have not come.
Others have not.
Okay, what is the facts first?
Facts, my lord, for your lordship's convenience, my lord.
Okay, 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 very good. Okay, this is list of this, no?
Yes.
Okay. Is that a written argument now, or it is already in the, where in the file? This we have already got it.
Oh.
Everything is there. 1, 2, this was kept in a separate file.
Yeah. Must have been. My lord, I'll just summarize, my lord. What had happened is, my lord, sometime in the month of August 2022, an advertisement was issued for, my lord, a selection process regarding the post of assistant engineer. Subsequently, it came out that there has been some leakages in the exam selection process. Investigation started. It's a pleaded case, my lord. It's a pleaded case. FIRs were lost, and that is how investigation started. And one person was identified also. Trial is going on in one case. Investigation is going on in various many cases. So subsequently, owing to that, 3 of the members and the chairman of the Public Service Commission resigned. And accordingly, this advertisement at page 62 came to be issued. If your lordship mindly at page 62.
Page
62.
66.
62, my lord. Annexure 4. Before that, I will just summarize what happened. Consequent to the advertisement, my lord, I applied, many people applied, my lord. I was recommended, cabinet approved, appointment order issued under 316 of the Constitution of India. When we were about to take oath, that was also fixed on the 17th of February 2023. Now, this social media campaign started, my lord, initially against the chairman. There are paper reports, my lord, on the basis of the average. They started protesting that this should be deferred initially. Then, my lord, on the day of 17th, my lord, when the oath taking was to take place, Itanagar Band, they blocked everything. Pitch battle with the paramilitary forces and all that. That is how the government succumbed, the cabinet took a decision to defer it. On the next day, my lord, these people, my lord, these editors, they got emboldened. They had a meeting with the government. On 18th of February, my lord, they succumbed and then they drew away minutes saying that we will remove them. And consequently, only on that basis was removed. So, my lord, my argument would be twofold, my lord. Once an appointment has been made under 316, even if I have not taken the oath, 317 will have to be resorted to, because I don't cease to be a member of a Public Service Commission just because I have not taken oath. Because the Constitution does not itself provide for taking oath also. It is by way of a notification this has come. The Constitution itself does not provide so. And assuming, my lord, say supposing the protection under 317 is not available, then also the manner in which the impugn actions were taken, succumbing to extra constitutional forces, that is wholly arbitrary, my lord. Even on that count alone also this cannot stand. That would be my lord.
Okay.
Best
Have you,
I have pleaded everything.
Where is the, because up till selection, there is no dispute.
Absolutely nothing. It is nobody's case that the selection was vitiated. It is only on the basis of that agitation, my lord, this has happened.
Now, where is that decision?
That decision, my lord.
That decision preceded your removal.
Yes, my lord, just a moment. Page 89.
Page 89.
Yes. Oh, sorry, man, 90.
90.
90. Annexure 14.
This is under challenge.
This is also under. Minutes of the meeting held in CM Conference Hall on 18th. There was a 13-point demand, my lord, that was placed by the All Nisi Students Union. They acceded to everything. Then at page 93. After 13, further the decisions were taken.
Page 93.
93, madam. Further the decisions were taken. Just again. A, the demand for cancellation of order, the present chairman and members of the Arunachal Pradesh Public Service Commission was agreed. The same will be taken to cabinet for approval. A fresh search committee will be constituted. A column for declaration of properties of all applicants will be added in the application form. This was signed on behalf of the government by the Secretary Administrative Reforms. And signed by the president of the All Nisi Students Union. There is a community-based student organization. Chairman of, these are a group of aspirants, my lord, so-called aspirants. It appears they formed a committee, my lord. Their chairman has signed it. Another person, my lord, who is there, I don't know. They have signed it. Was attended by, my lord, the Home Minister, another minister, another MLA, and all these people, my lord, we don't even know who they are. Nari Shakti and all these things are there.
These Nari Shaktis were kept under this Arunachal Pradesh preventive detention.
Yes, yes. That is what I am saying, my lord. They have agreed here, but thereafter they went after them. This PhD chairman, secretary, this Nari Shakti people, all of them.
I think I have also passed the judgment, rejecting one of them. I think Nari Shakti only.
Yes, Nari Shakti. So all these people, this Kipa Champa and all, my lord, they were under custody, under this preventive act.
That's your case.
If I may, my lord.
Yes.
Now, page 97.
Page 97.
Yes, this we have obtained through the RTI Act.
Yes.
Because in the government affidavit, they say that this is not the only factor that we have taken into consideration. Though there is no material on record to show anything. Page 97.
Page 97. No?
Yes. This, my lord, was on 9th of March 2023.
Just a minute, just a minute. 96, 97.
96 is the covering letter from the Legislative Assembly, Joint Secretary. He gives a copy of the answer made by the chief minister in the floor of the house. 98 is in Hindi, my lord. The translated copy is at page 100. Yes, my lord. Page 100. This is, my lord, the question by a member of the Legislative Assembly, Wan Nabung Tuki, leader of opposition. It says, Honorable Speaker, sir, the Honorable Chief Minister has answered the question number such and such. However, through you, I want to ask a supplementary question regarding the present status of appointment of chairman and members of the Arunachal Pradesh Public Service Commission, whether they are functional or not functional, or whether they have been removed. Then the reply, my lord, will say. Honorable Speaker, sir, as regard to supplementary question of question number 40, which has been asked by Honorable Member Sri Nabung Tuki in the floor of the House, regarding the status of the selection of chairman and member of the Public Service Commission, the government had appointed the chairman and members already. However, there has been protest and aspirant by submitting a memorandum wanted that there should be a constitution of new selection committee and there should be a new selection process for appointment of chairman and members. Anyway, considering the popular demand, my lord, the appointments already made after taking the view of learned senior advocate general, we have cancelled their appointment because the appointments were made, but no swearing in had taken place. Therefore, the appointments has been cancelled. My lord has seen, there is in the floor of the house, that is the reason, popular demand, my lord.
And the opinion.
In the opinion. Opinion is, they can be removed because the oath has not been taken. That is the opinion. That is the opinion.
Yes.
You know, Lordship, my lord, at page 101. This is the decision of the cabinet. Proposal for recall of appointment orders dated 7/2/2023. That is the date on which we were appointed. In respect of selections made of chairman, such as such. After detailed deliberations, the cabinet.
Where is that proposal for recall?
My lord, that I don't have. That must have, my lord, gone through the.
There must be some proposal.
Yes. That must have gone through, my lord, the AR department or something.
Because the proposal will contain the reason.
Yes.
Why this is proposed.
Yes. That, my lord, may be required. Otherwise, my lord, they have brought nothing on record. The 18-2 meeting, minutes of the meeting is there. They have said we will place it before the cabinet, and they have placed it before the cabinet.
So your argument would be.
Yes.
First, that once the
Yes.
appointment is made, they
Under
have no
316,
power
yes.
on To remove. Even if they remove, they will have to follow the procedure under 317.
Yes.
And third argument is that there is no constitutional provision for
For
removal
recall.
of,
Yes.
for swearing in.
Yes.
Therefore, the notification will not take over your right as appointed under 316 by virtue of that non-taking of the oath.
I'm also submitting, my lord, even if assuming, my lord, that has not been done, just because I have not taken oath, would not mean that I cease to be a member of the Public Service Commission once that appointment is made under 316.
Okay. And other argument?
And my lord, assuming, my lord, because I have not taken oath, and assuming the protection under 317 is not available to me, then also, my lord, in a democratic polity ours, where the rule of law has to prevail,
Notice.
can the government, my lord, on the basis of a law and order situation, my lord, can recall
On
our-
demand of extrajudicial
Yes,
authority,
yes.
reason of removal.
Reason of removal. It's apparent because there was an.
According to reason of removal is not sustainable
Yes,
under law.
yes.
And
My lord-
this is not for any valid reason, but
Yes.
for pressure from the
Yes.
extrajudicial authority.
Yes.
It is.
Yes, my lord, in fact, we have pleaded, my lord, we have gone to the extent of saying, this was on 18th of February. This agitation was going on, the minister was drawn up. I will take you through, lordship, through the readings also. We have said on 20th, the president of India was supposed to come here in the state for the statehood day functions. Because of that, my lord, they have succumbed to this. They have said no comments. They've accepted it. If you're, then I will just take a lordship through that also. Thereafter, my lord, I was just pointed out, after said detailed deliberations, they have taken this decision. But earlier also they had the same language. After detailed deliberations, my lord, our appointments were, my lord, approved. Then this notification at page 102 came. Recalling
It is
our.
impugned.
Yes. So, Lord, take your lordships through our appointment orders also.
Page 103.
102, man.
102. Yes. 102 is the withdrawal.
Yes. Our appointment is, my lord, this earlier.
Page?
Our appointment, my lord, will kindly have page 62 first. This is the advertisement.
62.
And issued for, my lord, 1 post of chairman and 3 members of the Public Service Commission. The eligibility criteria is clause 1. Persons with outstanding career, outstanding academic excellence, capacity to judge independently suitability of candidates for a civil post or which under the government of the place. He shall not be a member of such and such and such. So this is the advertisement, man.
What is the notification of taking oath?
Then your lordship will find in the government affidavit. One of them I have annexed also. The other one I did not have. Page 17, my lord, affidavit of the respondent numbers 1, 2, 3, and 4. In exercise of powers conferred by the proviso to Article 318 of the Constitution of India, the Governor of Arunachal Pradesh hereby pleased to further amend the Arunachal Pradesh Service Commission Regulation 1988, namely, such and such. This is an insertion of clause 4A. In the Arunachal Pradesh Public Service Commission Regulation 1988, after clause 4 of the following shall be inserted. 4A, the Governor of Arunachal Pradesh or his nominee shall administer the oath of office to the chairman and the members before entering upon their office on the following form. This, my lord, would only mean, my lord, this will only bar me from starting to discharge my duties as a member of the commission. This cannot mean that once appointment is made on 316, Just because I have not taken out would not mean that I am not a member of the commission once the appointment has been made. And the second one is at page 19. This is the oath of secrecy.
Just a minute.
Right.
Okay. Anything to be added?
Just for the purpose of showing, my lord, how the appointment, if you can take a lordship to the documents. Page 62 is the advertisement. Page 71 is my application. The board proceedings, your lordship will find at page 77. This was a committee headed by the retired chief secretary of the state. The present
Page 76.
77, man. 76 is the notification constituting the committee.
Page 77.
Yes. And one was the vice chancellor of Northeast Hills University. My lord, for the post of chairman, there were 18 applicants. For the post of members, my lord, 58 applicants.
Page 82 is your appointment.
Yes, 80, your lordship will have a look
82.
first. 80 first. Because here also they say after
It
detail.
is approval. Page 80 is approval.
Yes, I am showing this for the purpose of showing that after detailed deliberation, yes. Because the argument was advanced on the last occasion that while recalling that. Yes, 82 is my appointment. Your lordship, we kindly have page number 87.
That is the fixing of the.
Yes. So it is not that the government on their own had anything regarding the selection being bad. Because they wanted to swear us in. '89 is the postponement of the swearing in. I've given it a list of dates. Right?
Yes, I've seen that.
So these are the facts, madam. So the Rosin may kindly have the constitution.
Yes. Just a minute.
Madam.
Now all are in two sets.
Yes. I have quoted the judgments also in the written argument.
I've seen them.
That is the same thing I will be submitting actually. Only thing I wanted to point out from here, this
317.
16 first, man.
Okay.
16.1 I will not refer to because this is the for the appointment matter. Two, the state is relying upon, that is why I would like to place this matter. 316.2. A member of a public services commission shall hold office for a term of 6 years.
Which one you are reading? 316.
316.2 matter.
3162.
Yes.
Okay.
A member of a public service commission shall hold office for a term of 6 years from the date on which he enters upon his office or until he attains in the case of the such and such. This enters upon this office, my lord, it would mean, my lord, in this case, because there is no provision for taking oath, the day I join and start discharging my function. Appointment is made under 316.1, my lord. 316.2, my lord, provides, this is for, my lord, calculating the date of my superannuation. Shall hold office for a term of 6 years. The term it is for the purpose of that matter. Because the Constitution itself does not provide anything for taking oath. So the understanding I have is that once an appointment is made under 316.1, I will have to join my office. Then thereafter I start discharging my function. So once an appointment is made under 316.1, my lord, the only way a member can be removed from office is by taking reports to 317, which admittedly has not been done.
Yes.
I have not been able to lay my hands on any direct judgment regarding, my lord, the member of a public service commission taking oath, but it's not there in the Constitution itself. But my lord, as far as the try to draw some analogy from other, my lord, Constitutional provision. My lord knows under Article 188, a member of a legislative assembly has to take oath before starting his legislative functions. Now, on this line, my lord.
No, here their argument will be under 318.
Yes.
There is a power to determine the number of members of the commission and their condition of service.
Yes.
And they will also argue, I do not know subject to
Yes.
what the Advocate General says. Condition of service will include the mode of joining. Or mode of joining will include swearing in.
Yes.
And that has been, they have done it. So you cannot say that swearing in is not permissible under
I am not saying that.
under the 380. That will, I think that will be too far reaching,
Yes.
that they will have no power to incorporate a swearing.
I am not arguing that, my lord. My argument is, even if assuming, my lord, I am required to take oath, once this appointment has been made under 316.1, I do not cease to become a member of a public service commission.
Your
only bar.
Your whole case will be that it is absolutely arbitrary.
Yes.
And it is on the basis of a pressure created by a third party,
Yes, yes.
not by an independent decision even of the cabinet.
Yes. Yes.
This is
my main crux of my argument.
even of the
Yes.
cabinet.
Yes.
This is admittedly under pressure, and you will further argue that the government in its affidavit
Yes.
has even relied on that thing that they have decided, they have relied on the memorandum of all Nisi Students Union.
Yes.
Then and the cabinet decision of the cabinet, also the reason is suspension is the reason of this reservation. Arunachal Indigenous Tribe Forum
Yes.
and Pan Arunachal Joint Screening Committee, the cabinet has decided to call off the swearing in ceremony.
Yes.
That is their admitted position. This is no dispute on
Yes.
that. Annexure D, page 26.
Yes.
This is a Chief Secretary comes Secretary to the Cabinet. Implementation of the above. Now subsequently, what is the deliberation of the Cabinet and reason and the proposal? That is very vital.
Records was produced last.
So far as the facts are concerned, we are not in any way disputing. So if the argument is on facts, that there were agitations, ban calls, etc., and the ultimate decision culminated from there. That is our pleaded position even in our affidavit. So factually, we are not
no dispute.
It's purely a question of law on both the issues. As I have understood, my learned friend has been very precise to that extent. The challenge is twofold. That once appointed, although oaths may not be taken, only way to remove is under procedure 317. And the second argument is that even assuming that 317 will not apply, the reason is that the government acted on the agitations resorted by some organizations and the public, and that cannot be a reason
Ground
in the
for rejecting of a due selection process. That is the
Yes.
And admittedly, this is the reason of cancellation.
Thereafter, deliberations took place in the cabinet. Those are not disclosed in the cabinet minutes, but the resolution itself shows that the cabinet deliberated upon.
But there is a proposal.
That proposal we will have to.
That proposal comes from I believe, the air department. They put up a proposal.
But the cabinet says there was a proposal. How the proposal is mooted, even if cabinet deliberation court may look into it, no problem on that. And the proposal, there must be a proposal. Deliberation on the basis of the proposal. That it should be removed for this reason, or this should be this day should be removed because the public demand. And then deliberation, then proposal is accepted. What is the proposal? That might be
we'll produce it
important.
If possible today itself or tomorrow. That is not a problem.
No, I was submitting, my lord. I would like to, my lord, just read out 2 paragraphs, my lord, to show how the petition and the affidavit.
Okay.
It's an admitted case. Page 23, my lord, paragraph 24.
Page 23.
Paragraph 24. This is after, my lord, the swearing in was called off. In fact, my lord, from 19 onwards it is relevant, but I will not.
You want to see me page
23, my lord.
Of the writ petition. Paragraph 23.
24.
24. The consequence of the decision.
Yes. Well, from 23 onwards, seeing the large scale law and order disturbance, the state cabinet held the emergency meeting by virtual at 11 AM and decided to call off the swearing in ceremony of the chairman and members by succumbing to illegal demands of the agitators. That consequent to the decision of the cabinet to call off the swearing in ceremony of the chairman and members of the Arunachal Pradesh Public Service Commission, which was the primary demand of the agitation being carried out on 17/2/2023, the agitators became even more emboldened and continued with the agitation. Consequently, the Chief Minister of Arunachal Pradesh made a public appeal to defuse the situation. Accordingly, on the next day, that is 18/2/2023, while continuing with the agitation, a meeting was held in a conference hall of the Chief Minister with the representatives of the PHSC. The meeting was attended by the Honorable Minister such and such. 25. That to the knowledge of the petitioner, the meeting went on for around 8 hours at the government in order to assuage the situation, considering the visit of the Honorable President of India, who was to grace the occasion of the statehood day on 20/02/2023 succumbed and gave in to the pressure exerted by the agitators in what is an example of utter capitulation of democratic elected government who has sworn to the constitution to govern with the rule of law such and such. These allegations, my lord, they have said no comments.
Which paragraph? Reply?
20. Reply is
Paragraph
15.
Para 15, page
8. The statements made in paragraph 24 and 25 being matters of record. The answering respondents refrain from making any comment thereon. And this is exactly what happened. My lord, for the purpose of my lord supporting my submission that even if I don't take oath, I don't cease to become a member of the Public Service Commission, my lord, I would like to rely upon the judgment of the Honorable Supreme Court.
Yes. Which one?
2018 6 SCC.
There are some judgments.
692. I have in fact quoted in the written argument.
You have quoted?
Yes.
Yes, let me see. Which judgment?
2018 6 SCC 692. My lord knows under 188, my lord, member of the Legislative Assemblies are required to take oath. (692). Paragraph 27 onwards.
Paragraph 27.
Yes. Here's the MLS had not taken oath, but participated in MLR, no contest. The legal position having been settled for over 100 years, we see no dire necessity for any at all of overturning the law laid down. 27 on. In Bhupendranath Basu versus Ranjit Singh Bahadur, the question related to the election of two non-official additional members of the Council of the Governor General. It was alleged that two electors had not taken the oath of allegiance and therefore the election of non-official additional members was void. An unsuccessful candidate in the election questioned the validity of the election and sought the recounting of votes after excluding the votes of the two electors who had not taken the oath of allegiance. The Calcutta High Court referred to such and such, which noted that the person is admitted to a public office which requires the oath of allegiance only when that oath is taken. However, the relevant regulation did not address this issue. It was held that the purpose of performing legislative functions conferred by the regulation, it was a necessary requirement that the oath of allegiance is taken. The mere fact of omission to take an oath of allegiance did not ipso facto cause a member to vacate his seat. Additionally, regulations such as such give discretion to the Governor General to declare a seat as void if elected person fails to take the oath of allegiance. In the cited case, the Governor General had not exercised such an option. Therefore, the mere fact that two elected members did not take the oath of allegiance did not result in their participation in the electoral process as illegal. A somewhat similar situation arose in Pasupati Nath Sukul versus Nemchandra Jain. In this case, a member of the Legislative Assembly who had not taken the oath of office had proposed a candidate for election to the Rajya Sabha. According to the law laid down in such and such, this court held that as long as the name of the elected member appears in the notification published under the provisions of Section 73 of the Representative People's Act, the member can take part in all non-legislative activities of an elected member. Reference was made to Article 188 of the Constitution of India, which provides that every member shall, before taking his seat, make and subscribe an oath of affirmation according to the form set out for the purpose in the third schedule of the Constitution. Paragraph 32. In view of the above, it was held that since the name of the proposer appeared in a notification under Section 73 of the Representative People Act 1951, there was no infirmity in the nomination of the candidate to the Rajya Sabha. I mean, trying to draw analogy from this matter.
You will say that similar proposition in the amended regulation whereby taking oath of affirmation is also mandated. When the constitution mandated under 188 is interpreted in this way, therefore the present case, the rule, amended rule and regulation where which mandates the swearing in ceremony should also be treated in this manner.
Well, I would, I mean, it would only mean that I cannot start functioning as a member of the Public Service Commission,
you'll remain
but
in-
I do not cease to be a member of the Public Service Commission. So the protection under 317 will apply.
So you have not, according to you, entered into, even if you are not entered into the
Yes.
office,
Yes.
because you will enter into the office after
Taking
taking
oath.
this, taking the oath. Even
Yes.
if you are not entered into the office,
Yes.
your selection as member remains, and therefore you are entitled to protection under 307.
Exactly. I'm also relying upon paragraph 50.
Paragraph
50.
50.
706. I'm not bothering on all the paragraphs. I'm just defining. Paragraph 50. When we read both the observations together, it is obvious that a member who is elected to a house does not cease to be a member only because he had not subscribed to the oath unless there is a specific provision in this regard. I'm relying on this, man.
You have quoted in this in
I have quoted it in it. Then, my lord, there was a case, my lord, of our own High Court. One executive magistrate was appointed as a judge of this High Court. Before he took oath, writ petition was filed, stay was granted. Ultimately, the matter was transferred to the Honorable Supreme Court. The Honorable Supreme Court interfered with the appointment. Warrant was also issued. Appointment because he was not qualified to be a judge of the High Court. But the Honorable Supreme Court held these are extraordinary circumstances. Even if he has not taken oath, 217 will apply.
That is the infamous
Srivastava.
what was that?
Padma Prasad. Yes. That observation I would like to rely. It is, my lord, 1992 to SCC 428. So they have to, 27 to rely, 27, 28. Facts are given in the earlier part, my lord. Interim order was granted, my lord, before oath was taken. Ultimately, matter was transferred to the Honorable Supreme Court. Paragraph 27 and 28, my lord.
Paragraph
27 and 28. He judges bench. Page 450.
Just a minute.
Okay. It is for the first time in the post-independent era that this court is seized of a situation where it has to perform the painful duty of determining the eligibility of a person who has been appointed a judge of the High Court and who is awaiting to enter upon his office. We looked into the official records and permitted learned counsel for the parties to examine the same. We are at loss to understand as to how the biodata of such and such escaped the scrutiny of the authorities during the process of consultation under Article 217, one of the Constitution of India. A cursory look at the biodata would have disclosed that Srivastava was not qualified for appointment as judge of the High Court on the admitted facts, which has been on the official file all the time. Needless to say that the independence, efficiency, and integrity of the judiciary can only be maintained by selecting the best persons in accordance with the procedure provided under the Constitution. These objectives enshrined under the Constitution of India cannot be achieved unless the functionaries accountable for making the appointments act with meticulous care and utmost responsibility. Mr. Sasensa vehemently argued that in case we come to the conclusion as we have that on the basis of the biodata taken into such and such, is not qualified for appointment as a judge of the High Court, then his appointment be quashed on the ground that there has been violation of Article 217(2) of the Constitution of India, and there was total lack of application of mind on the part of authorities responsible for making the appointment. We can adopt this course, but after hearing such and such, appearing for such and such, we refrain from doing so in intent, going into further matter placed on record by such and such to show that non-business biodata before the authority is qualified to be appointed as a judge of the High Court. We are fully aware of the delicacy and sensitivity of the matter and the stage at which the matter has been brought before us for judicial scrutiny, but I'm relying on this part. We make it clear that ordinarily the domain in such matters lies only with the constitutional authorities mentioned in Article 217 of the Constitution, but in exceptional circumstances like the present, where the incumbent considered appointment as judge does not fulfill the qualification under the provision of the Constitution itself, it becomes our bounden duty to see that no person ineligible or unqualified is appointed to a high constitutional august office or judge of the High Court. So, my lord, here was a situation, my lord, a person was awaiting to enter into office. The oath was not taken. Even then, my lord, this observation has come. Here, my lord, this person was not qualified. Rightly, the Honorable Supreme Court has interfered with his appointment. But the observation by the Honorable Supreme Court is there, my lord. Ordinarily, it would have been, my lord, 217 would have to be resorted to for removal, the constitutional provision. That is my humble submission in this case also. This is also a case, my lord, where the oath was not taken. And that is how this observation came to him. When I am asking myself a question, my lord. Once a warrant is issued for, my lord, appointing someone as a judge of this Honorable High Court, the Constitution itself provides 219. A judge appointed to be a person appointed to be a judge of the High Court is required to take oath. But once that appointment was issued under 217, my lord, can a Honorable Judge of this High Court be removed by the Honorable President just like that? No, I don't think so. Same with the MLA also. He can be only removed in terms of what is there in the Constitution.
According to when the appointment is done,
yes,
you are a member or chairman whatsoever. So your removal, once the notification of appointment is issued, swearing is a mere formality. You will not cease to be a member of. You may not be allowed to function.
Yes,
but you will still remain. You are already been selected and notified as a member of the Public Service Commission in terms of 316. Therefore, 317 is to be applied.
Yes. And my lord, that apart, my lord has seen the manner in which the decision has been taken. How can a, my lord, democratically elected government take this sort of decision? On that, my lord, arbitrary action, my lord, I would like to rely upon one. I have in fact, my lord, quoted it. I am a Sri Lanka Vidyarthi, I am relying upon.
Arbitrary.
Absolutely no reason, my lord. Absolutely no reason. And who are these people? Who they represent, my lord? This student organization, my lord, knows there are more than 120 tribes in the state, my lord. This student organization represents only one. And if your lordship goes through the demand that the government has acceded to, the 13-point demand, most of them, my lord, the government could not have. It's unbelievable.
You do one thing, you give a list of the judgments. Right. So that I can collect it and read the judgment instead of, I'll also go through the judgments.
Yes.
Though you have quoted the judgments in some of the cases, all of the cases, but not all the paragraphs.
Not all the paragraphs, the relevant paragraphs that I'm relying upon. I will give the list, man. Only one more judgment I will just read for 5 minutes. Sri Lanka Vidyarthi.
These two are there, and then arbitrariness.
Yes.
You want. So, what was that?
1991, 1 SCC 2121.
Paragraph
33 to 39. Your lordship.
Just a minute. Yes, so Dure, how do you propose today to continue?
Yes, I'll take
This is the only
I'll take half an hour.
Okay.
We can conclude by 2:30, 2:45 latest.
Just a minute. Just let me.
Yes.
no doubt, it is true, as indicated by us earlier, there is a presumption of validity of state action and the burden is on the person who alleges violation of Article 14 to prove the assertion. However, where no plausible reason or principle is indicated, nor is it discernible, and the impugn action therefore appears to be expressly arbitrary. The initial burden to prove the arbitrariness is discharged, shifting the onus on the state to justify its action as fair as reasonable. But in my humble submission, my lord, there is nothing, my lord. In the affidavit also, there is absolutely nothing. No reason. The only reason is because of the agitation, my lord. If the state is unable to produce material to justify its action as fair and reasonable, the burden on the person alleging arbitrariness must be held to be discharged. The scope of judicial review is limited as indicated in such and such to oversee the state action for the purpose of satisfying that it is not vitiated by the vice of arbitrariness and no more. The wisdom of the policy or the lack of it or the desirability of a better alternative is not within the permissible scope of judicial review in such cases. It is not for the court to recast the policy or to substitute it with another which is considered to be more appropriate once the attack on the ground arbitrator is successfully repelled by showing that the act which was done was fair, reasonable in the facts and circumstances of the case. As indicated by such and such, the power of judicial review is limited on the grounds of illegality, irrationality, and procedural impropriety. In the case of arbitrariness, the defect of irrationality is obvious. In our opinion, the White Seal Article 14 undoubtedly takes within its fold the impugned circular issued by the state of UP in exercise of executive powers, irrespective of the precise nature of appointment on the government council in the districts and the other rights contractual or statutory which was appointees may have. It is for this reason that we base our decision on the ground that independent of any statutory right available to the appointees and assuming for the purpose of this case that the rights flow only from the contract of appointment, the impugned circular issued in exercise of executive power of the state must satisfy Article 14 of the Constitution, and if it is shown to be arbitrary, it must be struck down. Article 35. It is now well settled that every state action in order to survive must not be susceptible to the vice of arbitrariness, which is the crux of the Article 14 of the Constitution and the basic to the rule of law. The system which governs us, arbitrariness is the very negation of the rule of law. Satisfaction is the basic test of in every state action in sine qua non to its validity, and in this respect, the state cannot claim comparison with the private individual, even in the field of contract. This distinction between the state and the private individual in the field of contract has to be borne in mind. The meaning and true import of arbitrariness is more easily visualized than precisely stated or defined. The question whether an impugned act is arbitrary or not is ultimately to be answered on the facts and in the circumstances of a given case. An obvious test to apply is to see whether there is any discernible principle emerging from the impugned act, and if so, does it satisfy the test of reasonableness. Where a mode is prescribed for doing an act, and there is no impediment in following that procedure, performance of the act otherwise in a manner which does not disclose any discernible principle which is reasonable may itself attract the vice of arbitrariness. Every state action must be informed by reason, and it follows that an act uninformed by reason is arbitrary. Rule of law contemplates governance by laws and not by humor, whims, or caprices of the men to whom the governance is entrusted for the time being. It is tried that be you ever so high, the laws are above you. There is one man in power, must remember always. Almost a quarter century back, this court in such and such indicated the test of arbitrariness and the pitfalls to be avoided in state actions to prevent that vice is in a passage as under. In this context, it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law upon which the whole constitutional system is based. In a system governed by rule of law, discretion when conferred upon by the executive authorities must be confined within clearly defined limits. The rule of law from the point of view means that the decisions should be made by the application of known principles and rules, and in general, such decisions should be predictable and the citizen should know where he is. If a decision is taken without any principle or without any rule, it is unpredictable, and such a decision is antithesis of a decision taken in accordance with the rule of law. Then paragraph 38. Long strides have been taken in several well-known decisions of this court, expanding the scope of judicial review in such matters. It has been emphasized time and again that arbitrariness is an anathema to state action in every sphere, and wherever the vice requires, this court would not be impeded by technicalities to trace it and strike it down.
Yes.
And 39 also. My lord has seen, my lord. The 18 minutes, the statement of the chief minister on the floor of the house, they have admitted it. Is this the manner in which, my lord, the elected government, my lord, has taken oath to, my lord, abide by the rule of law, my lord, functions. And paragraph 24 and 25, my lord, have seen, they have admitted that. That is,
We'll continue at 2.
Case, my friend read out also, in paragraph 21 and 22 of the writ petition, his pleaded case is that thousands of people started gathering and agitation started after the appointment order was issued. And the swearing in ceremony was fixed on 7th of February. Now, what I would like to lay emphasis on is this manner and the sequence of events, the manner in which the decision was taken. The first thing what the government did was held an emergency cabinet meeting. And in that cabinet meeting, it was not decided to remove. What was decided was that there is large scale agitation happening. Let us keep the swearing in on hold. And thereafter, we will examine the issue. That is exactly what happened. After that, again, that document has also been placed. I will place once again tomorrow, my lord. Thereafter, all the stakeholders were called in presence of the officers, the chief minister himself. There, all their grievances were heard. After hearing, they raised one very pertinent issue, that in the past, the Public Service Commission members have been resorting to various anomalies. And in fact, in the very recent past, what has been pointed out by my learned friend, that there was a very serious anomaly in respect of some examinations, selections, where ultimately inquiries had to be directed. There are trials going on now. One of their demands was, which I will again place tomorrow, was that the integrity of these members also needs to be verified. And one way of doing it is to ask them in the advertisement itself, you should ask them to disclose their income and their property. That will be an indicator whether a man has some indication. In any case, that was one of the demands that was accepted, and in the fresh advertisement, which is under challenge now in this writ petition, besides challenging their removal, they have also challenged the fresh advertisement. In that advertisement, I'll point out that that has been incorporated now as a condition, that you will have to disclose your entire property, which will throw light about the person's integrity. Because the moment we know that, let's say a person is a teacher in a school, how has he amassed so much of property? That can be an indication, be that as it may. After discussing with the stakeholders, the matter was now placed before the cabinet. The cabinet deliberated on it and said, and in the meantime, as has been pointed out, the opinion of the learned then senior additional AG was also taken. And having considered the fact that Article 317 does not come into play, an order was issued recalling their appointments. Now the question of law that arises before your lordship is whether in these facts 317 will be attracted or not.
That is the
and
issue.
I will satisfy your lordship from the constitutional provision 316 read with 317 that 317 will not apply. There are, in respect of High Court, I think it was the High Court of Patna. This situation arose in 1950 or 62. I will place those judgments. There is one Allahabad High Court judgment, one Calcutta High Court judgment, and one Patna High Court judgment, another Kerala High Court full bench judgment. A situation had arisen very interesting. There was a form of oath which still exists for the honorable judges to take also. The form is in the constitution itself. The form underwent an amendment. There was a constitutional amendment. So, I'm forgetting it, whether it was Patna High Court or this was Allahabad High Court, 1965. 3 judges were appointed They took oath in terms of the
Unamended.
unamended oath. The High Court registry had overlooked the fact that in the meantime, after their appointment, there is an amendment of the Constitution. A question arose before the Allahabad High Court as to whether they have entered upon their office or not. And in that judgment, relying upon Allahabad High Court relies on Calcutta and Patna to say that the form of the oath may not be too much relevant. However, taking of oath for entering office is a mandatory precondition. The clock will start ticking. Just to give you an example, my lord. When your lordship was elevated, tomorrow morning is the oath at 10 o'clock or 10:30. How is the cause list published? It is not.
Yes, it's just designate.
Judge designate, even that is not written.
There in the cause list, dot, dot, dot.
Dot, dot, dot. The reason is.
You are not a judge yet.
Yeah, exactly. And by virtue of the same logic, in fact, in respect of the Calcutta High Court judgment, a question had arisen whether after we attain independence, any action taken by the president before the president took oath. The president had taken oath at 10:15 in the morning. So, Calcutta High Court held that he had not entered upon his oath. So, my endeavor from these judgments will be to show that entering upon an
office. That is a vital law, entering into the office.
Yes, and Article 316, if you that is why my learned friend placed 317. If your lordship reads the language employed in Article 316(1) and 316 proviso as well as the 316(2), if your lordship kindly takes up for a moment. The constitution makers were very conscious about the words used. If your lordship first takes up 316(1), the chairman and other members of a public service commission shall be appointed. Your lordship will mark this word, appointed, in the case of the union commission or a joint commission by the president, and in the case of a state commission by the governor of the state. Now, we may skip the proviso. Now, your lordship will come to 1A. Before 1A, my lord, may I first place 2? A member of a public service commission shall hold office for a term of 6 years from the date on which he enters upon his office.
I have marked it.
So, it is not from the date of appointment. It is from the date of entering upon the office. So, the tenure starts from the date on which he enters upon the office. Now, the fact that the constitution makers were conscious about the difference between appointment and entering upon office is reflected from 1A. Your lordship will kindly see 1A. If the office of the chairman of the commission becomes vacant, or if any such chairman is by reason of absence or for any other reason unable to perform the duties of his office, if I may pause here for a moment, the constitution makers envisaged 2 situations. One was a vacancy arising, and the other was by reason of absence if he is not available. Those duties shall, until some person appointed under clause 1 to the vacant office has entered on his duties thereof, or as the case may be, until the chairman has resumed his duties. So when he is absent, he has to resume his duties. When he is appointed, he has to enter upon his office. Only during these periods be performed by such one of the other members of the commission as the president in the case of the union commission or joint commission, and the governor of the state in the case of a state commission may appoint for the purpose. So, the constitution makers were very conscious about the difference between being appointed and entering upon office. And that is why now, if your lordship sees 317 in this context, the word used would have been, had the argument advanced by the petitioner, if it is to be accepted, the language used in 317(1) would have been that appointment can be terminated. The language used is something else. Subject to provisions of clause 3 of the clause 3, the chairman or any other member of a public service commission shall only be removed from his office. Otherwise, the constitution makers would have said terminate his appointment.
So you want to relate it to entering into office and remove from his office.
Therefore, 371 is...
And your argument is until and unless he enters his office, his removal from office
does not even arise.
That
Therefore,
370 will not be required.
therefore, 317.1 is not correlatable to 316.1. 317.1 is correlatable to 316.2 only. Because the word office is used not in 316.1, it is used in 316.2.
2 and 317.1.
317. The word office is not even uttered in 316.1. So on that I will place judgments well. And so far as my lord, this the other limb of the argument is concerned, agitation. Your lordship will find it is his pleaded case at paragraph 21 and 22. The thousands of people gathered. One call was given. And agitation happened. The argument is that since it is a consequence of merely of an agitation, the action is bad. If a consequence of agitation is bad, this was my argument before my Lord Justice Tagia also. Indian independence would have been struck down by the British courts. Agitation led to Indian independence. We are a democracy where fundamental principle is of the people, by the people, for the people. Your lordship will not find a single material on record by any organization or anybody from the public saying that we oppose what has been demanded by the public. There was an overwhelming demand and no one opposed that demand. So if we go by if a government, elected government goes by the public demand, can it be by itself be a wrong decision?
Or can
Had it been
judicial review?
Had it been the case, I am forgetting the Indian independence. Your lordship will recall the amendment to the Citizenship Act, Section 6A. There was an agitation led by ASU, a students' organization. Ultimately, the parliament made an amendment to the Citizenship Act and Section 6A was inserted. And I will place the statement of objection reasons. In the statement of objection reasons itself, it is written that it is a consequence, 6A is a consequence of agitation. Borough Accord. The 6th schedule was amended. Again, a consequence of agitation, public demand. So merely because it is a public demand and the government listens to public, can it be by itself
extrajudicial or extra constitutional?
The Citizenship Act specifically refers to ASU. ASU can also be termed as an extrajudicial organization. What is ASU? Here also some organizations, students' organizations, various community-based organizations came forward, demanded, they said that no, we want, since it is a constitutional body, we want a fair and transparent selection to be held before you appoint a chairman and members. We examined that. After taking into account all the demands by the stakeholders, matter went back to the cabinet. Cabinet deliberated upon it and thereafter said that in public interest, we hereby decide to recall the orders of appointment. So broadly speaking, my lord, it is already 2:15. I won't trouble your lordship any further. Tomorrow I will wrap up in half an hour.
Tomorrow, and when Dilip Majumdar is when?
He is also planning to argue tomorrow itself, depending on your lordship's convenience, or else if your lordship
Monday.
There is a Monday.
Maybe Monday.
I will have to give reply.